Good afternoon, good morning, good evening. It just really depends on where you're watching. But hello, Law Nerds. Happy Friday. It's September 19th. As you know, I know, we know, everybody knows, it's been a lot of travel on my end, but I'm so glad to be here with you today. We have a few things to talk about with Donna wanting a new trial. Donna wants a new trial because of course she does. Of course she does. And so we are going to take a look at that motion and see where we get. But with all of it, I am A, ready to see you because I've missed you guys, and B, ready to take a look at this motion. I haven't looked at it. I saw that it was filed. We knew that it was going to happen. Every single trial, there's always a motion for new trial if there's a conviction. So of course we're going to have to talk about it. I want to see what she has to say. I haven't read it yet because I have been on so many planes. The fact that I don't know what time zone. I'm pretty sure I'm in Central Time today because we're home. It's just, oh my goodness, it's been so much. But during Q&A, when we get to Q&A a little bit later in the stream, I will talk about going to Made on YouTube, being invited there and hosted by YouTube for Made On. We will talk about that if you guys are curious. We will talk about the other travels. Travis and I went to go see My Chemical Romance. It's literally all I can talk about. And I got to spend some time with Sir Mix-a-Lot before that. But it has been plane, more planes, all the planes. And now I am home for a minute and just doing the busy life things that come with having a senior in high school. Because of course it does. But with all of that, Donna wants a new trial. This is the beginning of a long process of what will eventually be her appeals. Motion for new trial is not the same as an appeal. There will be an appeal too. We'll talk about it. But I have missed you guys. It was great travels. I have to ask you if you've noticed what's not in the chat today. Chat. Have you noticed? Have you noticed that the leaderboard is gone? YouTube got rid of the leaderboard for us. YouTube got rid of the leaderboard. It's gone. I know. You don't have to opt out on your end because YouTube allowed us to opt out on my end. So the channels will get to choose if they opt in or opt out. And I'm so excited. So if there are, channels will get to choose. And that's when I talk to YouTube about things, I always ask that we get to choose. I mean, I've definitely said, if we can't add people on mobile, what are we even doing? Apparently that's way more complex than I ever anticipated. But I was like, hey, can we just choose it? Can we just choose it, please? And guess what? They said yes. So we are waiting for the being able to add on mobile a little bit easier. We're waiting for that. But everyone is aware of it. And we are waiting for live chat to be the default. But there are some differences of opinions on that. So there are a number of us see that differently. But I'm like, okay, but please, please can live chat be the default, please? For those of you who are like, what is the leaderboard? Don't even worry about it. Some of you saw it on your end. Most of you saw it on your end. Some of you didn't, but it just was not the vibe for this channel. And the fact that we can now choose to have it turned off. I'm so excited. It didn't feel very YouTube-y to me. It felt a little more Twitch-like. And I think it's probably great for gaming channels and things like that. But you guys chat because you want to. You don't need something popping up and being like, hey, get 5 more points for chatting. Not the vibe. You guys chat when you have time. You get to choose. We're not trying to bump you and be like, chat more. Some days you have time for it. Some days you don't. But you don't need it nudging you all the time. Also, you guys are the top chatters, all of you. It's not a competition. We are all about community, not competition. We're not about trying to see who's doing the most. All of us do too much in our lives. If any of you in the chat feel like you do not have enough to do, please let me know how you've managed it, because I can't figure it out. All of us have enough to do. We don't need anyone being like, today you need to do more. No, we don't. Generally, my message to all of you is, please try to do less, because you are doing so much, and everything is a lot right now. So what you don't need is to do more. You need a place where you get to do what feels right to you day by day. Like, you get to pick if today's a chat day, if today's not a chat day. Some of you, today's not a chat day. That's okay. I still see you. It's all right. Some days you want to engage more. Some days you want to engage in the way that feels best for you. You don't need anything nudging you and be like, do more, do more, do more. All of you live in a world where everything defaults to do more. We can default to do what works best for us, which might not be the way it works for everybody else. And that's okay. We get to do our own thing. We'll talk more about that later. I have missed you guys. It's just sometimes we need to take a step back to do a little bit less. And it's all right. I shared with you in the Lawnerd Lounge this last week. I shared on social a little bit that it's okay to pull back a little bit when you need to. All of you pour in so much to the people around you. And sometimes all you can do is pour into yourself to like stay upright. But what you don't have to do is constantly be nudged to engage everywhere all of the time. It's why we don't take streams down after stream, unless we've had horrible technical glitches and then we've created a new stream. Those will definitely go down. But it's because if replay is what works for you, then replay is what works for you. It's why there are some topics that we put up, the case briefs. So if you don't have the space to watch a full day of trial, you can catch up. I want you to be able to choose what's best. And that varies day by day, week to week. And I want to make sure that you have that choice, because in so many areas of your life, you don't get that choice. There are things in your life that you have to do. Everything is not that. And I feel like so much we live in everything has to be everything. It doesn't, but it takes a lot of energy to push back on everything has to be everything. There are things that must get done. Not everything is that. And so it's part of the reason I hated Leaderboard. It was like, you must. It's like, stop telling me what to do. Don't tell me what to do. And I feel that way on social media sometimes too, when I just need to pull back and be like, I can't look at everything. I need to just focus on what's in front of me. And that's okay. So I'm here to remind you that that's okay. Which is why today, all we're talking about is Donna. We will be talking about more things next week. Today, we're just talking about Donna. It's been a long 2 weeks. It has been a heavy 2 weeks. Your energy, your emotions, and everything else is being pulled in so many different directions. Today, we're just focusing on Donna. You've got it. We're just going to talk about damp dollars. Like, girl wants a new trial. Please, we watched your trial. That's it. We're just talking about damp dollars. And then we'll talk about YouTube and stuff. But we're not venturing outside like we normally do. We're not venturing outside. We're staying in our lane. That's what we're talking about. Of course, other things are going to happen. Other things are always going to happen. And what I tell you is when things happen in the world, especially things that are outside of where we focus, we are still going to be here. This community is still going to be here. There will always be a place to touch in, talk about the law, and focus on just what's in front of us. Somebody just said Famous Last Words. One of my favorite songs ever, by the way. I've been listening to it like on repeat because I had never seen it live before, and it just, my whole soul. But we're just going to focus on what's in front of us, and that's okay. It is always my goal to not have things outside hit you sideways as we're focusing on what's in front of us. It's why we don't cover breaking news, even if the breaking news is stuff that we are interested in, because it's like, this is what we're focusing on today, and that's what we're going to do today. And then later we'll talk about all the things as we get into Q&A, because some of you are just like, damn it, Donna, what did you do now? What did you do now? What did you do now? But I just want to say, even when we take little bits of time off here and there, we will always come back to this community. It will always be, I'm knocking on wood. I want to always be here with y'all. even if we take a little time off to go to concerts and go to YouTube and have the conversations to try to make the platform and the internet more law nerdy, which is what I want. I want to make it more law nerdy. I love this community. I want to make it easier for everyone to have their own version of what we've created. And I want to help, well, mostly the platform understand how we do things, because the way we do things on YouTube is different than how others might do things on YouTube. It is never my goal to just have more viewers, more numbers, more subscribers. It is always my hope to have more law nerds, and that those that want to be a part of our community will find us. That is always the goal. It is not just more viewers. We don't need more viewers. We need more law nerds. We need the law nerds that are out there to just know we're here with them. Because a lot of you, when you find this community, they're like, where have you been? I want to speed that up. The finding of like, where have you been? I want to make that faster. And that's always the goal. We need more law nerds to just know we're here for them, the same way that y'all are here for each other. So that is always the goal. And that's different than people who just are looking for, and there's, again, I don't have any judgment on it. There are some videos that they're like, everyone just needs to see this and know this. We're building community. We're not just building more eyeballs on a thing. I explained it to someone over the last week, like a dinner party or like hanging out with a handful of friends. But there are times when you are hanging out with a group and like one extra person gets added in and it throws off like the entire vibe. And so it goes from being a really great, comfortable conversation to the vibe being off. And a lot of you, when the vibe's off, will just pull back. Some of you, when the vibe's up, will just be like, okay, I'm taking over now. It's going to be my energy to make sure everyone feels okay. And that's a lot of emotional work, but I'm just going to make sure everybody's okay. And then it's trying to navigate, why are the vibes off? But when the vibes aren't off, it just flows. And that's what we're trying to create here. So we want to keep it easy peasy with the conversation. It shouldn't feel uncomfortable and like you have to be like, oh, vibes are off. And some days when we're in trial, the mods have a lot more work to do to keep that dinner party moving the way that it should. But when we're not in trial, then we get to just take a breath and get back to our law nerd chat. Occasionally, you know, people will wander in and we're like, where did you come? No, you've wandered in from the wrong side of the internet. So here are the rules. And if this is your side of the internet, great. And if this is not your side of the internet, fine. Just, if it's not for you, just go. It's okay. Just go. It's fine. You can go. I give you permission to not have to. So, Valkyrie said, so why are we live on a Friday? Because we weren't live all week. And I wanted to talk about Donna before we get into other topics next week, because we hadn't been live all week and I missed you guys. And so it felt, to me, waiting till Tuesday felt too long, and I was home today. And so we have time before we have like football games and stuff. So because I missed you guys, that's why. So before we dive into next week, we gotta talk about damp dollars Donna. All right. All the things. Let's roll the intro. Let's give a little bit of a road so far. Talk about what a motion for new trial is. And then we're just going to go through the whole thing. It's like 18 pages. That's what we're going to do today. And then we'll get to Q&A. How's that sound good on a Friday? Sounds good? All right. Cheers, everybody. It's good to see you. Well, don't worry. We'll talk a little bit about the Black Parade. I don't know if I'm going to be able to without starting to cry. It was that good. It was that good that I'm just going to be like, there are special moments in life. Getting to see MCR live was a very special moment in life. And it was so worth it. It was so much work. Concerts like that are so much energy to get to and to like do all the things and to park and to leave. It's so much energy, but it was worth it. But you can hear that I'm tired, right? You can hear how much I've talked over the last 2 weeks. So much. That's all right. Let's roll the intro. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. We have a little bit of a road so far that we need to do. Because for those of you that watched the entirety of the trial with me, perfect. You're in it with me. For those of you that have checked in and out, perfect. I've got you on the road so far. Look, everyone makes a motion for new trial after a conviction. If there's an acquittal, there's nothing to ask for a new trial on, right? Because you don't need to ask for a new trial. You're done. But if there's a conviction, the first step would be that motion for new trial. And you see it during trial too. So the prosecution does their case in chief. Then the defense is going to make their motion to dismiss or motion for judgment of acquittal. Depending on what jurisdiction you're in, they will call it different things. I believe Florida calls it a JOA, if I'm remembering correctly, but other jurisdictions call it motion to dismiss. I will use the two interchangeably that happen at the end of the prosecutor's case. Oftentimes you will see the defense renewing that motion. And we saw that in Florida versus Donna Adelson as well. We saw the defense make their motion for judgment of acquittal. Then they did their case in chief. Then they renewed the motion for judgment of acquittal. And we're like, hey, Your Honor. So I know that you said like, no, but maybe now? Maybe can we do it now? Pretty please, can we do it now? And the judge was like, yeah, still no. Still no. Just still no. And so the motion for new trial is not the same standard as a motion for judgment of acquittal. It is the step before you're getting another court to take a look on appeal. So it is asking the trial level, the trial level court, and asking the trial level court to evaluate whether or not a new trial should be granted based on reasons, sometimes vibes. We saw who made the vibes argument. Somebody, was it Sarah Boone's? Was Sarah Boone's argument basically like, but Your Honor, not intentionally, new trial. And the judge was like, yeah, no, just no. We saw the motion for new trial be pretty extensive in the Murdaugh case. And that motion for new trial has gone like up, down, all around. So that motion for new trial based on Courthouse Becky is still going through the appellate courts because of Courthouse Becky before we get into all of the appeals, right? They're still in kind of the motion for new trial. Now, when it gets to an appeal, generally the result on appeal is also a new trial. So it gets a little confusing. I think the easiest way to simplify it is what judge is evaluating the motion and what are they considering. So the motion for new trial is being evaluated by the trial judge saying, hey, judge, generally, you made some decisions. You've had a minute to think about it. Did you change your mind? Maybe we should have a new trial now. Don't make us go to like the appellate court and tell them that you made these decisions and they should change your mind. So it's being evaluated by the trial court. Do motions for new trial often go very far? No. Why? Well, they're telling the same judge the same essential thing that they said during their motion for judgment of acquittal or motion for dismiss. It's just an extended version of that, but it's also kind of a preview of what will go to the appellate court. But these are decided and argued by the attorneys in front of the trial judge, not in front of the appellate judge. So hopefully that distinguishes the difference and makes sense because that's what we're going to cover today. And the title of this already adds in one more quirk that we haven't mentioned. It's not just a motion for new trial. Defendant's motion for new trial and for leave to interview jurors. So we're not just looking at, hey, Your Honor, can we get a new trial? We're also going to see, based on the title, finger pointing, I imagine, at the jurors. I would guess that it's the jurors that spoke out, right? Because that's what we've seen in other trials. And we've seen jurors be interviewed. They were interviewed in Murdaugh. I know that others covered it. I didn't cover the Maya case, but we know that jurors were interviewed in the Maya case just based on everyone else who covered it. And then there have been other cases where jurors have been interviewed. We saw that in the Maxwell prosecution as well. Donna. Morgana said, are you covering the juror interviews? I covered the four-persons interview. I have not. Other interviews came out while I was traveling. So, Donna, what are we doing? Right? So we are going to jump into all of that. Jurors can talk after trial. It doesn't mean you get to interview them. I don't know what I think about this because I haven't read it yet. So we're gonna do it live. We're gonna do it together. And we're going to keep in mind that the standard for a new trial, especially from the trial court, is quite high and hard to meet. That's generally not what happens. And the leave to interview a juror, that standard varies by jurisdiction and varies quite a lot. So, Buffy asked, EDB, is your hair a new color or is it my TV? We refreshed the color. It's not just your TV. It's much more noticeable when I am in the sun. But yes, the hair is more purpley at the ends. And I will share some photos on Instagram later today where you'll see it. Those of you in the Lawnerd Lounge have already seen the refreshed color in the post in the lounge because Octo takes the world's best photos. And some photos of me were taken at YouTube events that are not the best photos of me by any means. But Octo makes everyone look good always. So the difference in how photographic I am really depends on where the camera is and how bright the flash is, because I've definitely seen some not great pictures of myself over the last few days. But you know what? We go to events. Who cares? I mean, whatever, right? There are some who probably look good no matter where they are photographed. I am not that one. So we got a little bit more purple in there. So no, your TV is not off. The purple, we can see the purple. Okay. Are we ready? Before we jump all the way in to this motion, because I don't want us to get distracted, we are going to take a moment because we have a stream sponsor today. And not only do we have a stream sponsor today, but Incogni, every time I sit down to talk about Incogni, we talk about another data breach. And in the time since I've recorded this and now there have been others, please listen when I say that data breaches are getting more frequent and more significant and more concerning. So I love that I get to work with Incogni to share with you a tool that really takes the heavy lift out of protecting your information. So we're going to share our sponsor real quick, and then we're going to go to court. Deal? Does that make all of the sense? I hope it makes all of the sense. Let me make sure my audio is in the right place, because I feel like it's something that is so needed, but we put it off because it's just like, it feels so adulty. It's like, la, 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 whatever. I promise you, Incogni makes it easy. Incogni makes it easy. Let's say thank you to our sponsor, Incogni. A huge thank you to today's sponsor, Incogni. Every time I read a headline about a massive data breach, I do not have heart palpitations because I know that Incogni has me covered. Look, I was just reading about this massive data breach from AT&T. Data was exposed from 86 million customers of AT&T. It also included more than 44 million social security numbers. Keeping your information off the internet is imperative at this point. Incogni keeps an eye on your information so that you don't have to spend your days scouring the internet to see if somebody else has access to your social. Of course, Incogni has the automated removals that you've heard me talk about, saving me hundreds of hours of trying to get my data off these data broker sites and more. Incogni also has plans that have custom removal features that go beyond just the automated removal process if you need to get your information taken down. And if you're ready to try it for yourself, Incogni is available risk-free for 30 days. That means you can try it out for yourself and get a full refund if you're not happy with the service. So go ahead and use code EmilyDBaker at incogni.com/EmilyDBaker to get 60% off. Yes, you heard me correctly. 60% off an annual Incogni plan. So use code EmilyDBaker at incogni.com/EmilyDBaker and get that 60% off your annual plan. Not only will you get your information off the internet, but it will also give you a peace of mind. Let's get back to today's stream. Thank you, Incogni, and thank you, Law Nerds. And yes, I've seen many of you that already have Incogni. Fantastic. I've seen a lot of you be like, yes, I stand by this catfink. Thank you for sharing. Said, as an InfoSec professional, I totally agree with this. Already have Incogni. And I mention it in most of the times I talk about Incogni. They have the option for a plan for you or a family plan. Because I do not have time to go find every data broker service that has my information. I wish I did. Could I do it for myself? I don't have the time. Truly, I don't have the time. I don't have the energy, and it stresses me out. So if it's something I can pay to have somebody else handle, done. And I've done it for my parents and my kids. I just want it to be handled. So we now have it handled. Okay, let's talk about Donna wanting a new trial. Donna wants a new trial. Let's find out why. It's good. I imagine it's going to be much of what we've already heard the defense argue about, but based on this title, we are probably going to get some more information about what they think about the jurors. This was filed on 9/15. Was that this week? I think that was this week. What day was it this week, chat? What day is it? Today's the 19th. So Monday? This was filed on Monday. Emily, where were you Monday? I was on a plane to New York. Where were you Tuesday? At Made on YouTube with YouTube. Because they brought me to Made on YouTube, which was insane. And then I went to YouTube's podcasting event on Wednesday. And then I was on a plane Thursday, and now we're here. Emily, weren't you on a plane Sunday? Yeah, I was on a plane Sunday, and then Monday, and then, yes, all. I'll be back in a time zone at some point. I don't know. Maybe. We'll see. Let's figure it out. Defendant's motion for new trial and for leave to interview jurors. Okay, Donna, why do you want to interview the jurors? That's the thing I'm most interested in, because the leave for new trial is going to be the same thing we see in every motion, which is just, OMG, you didn't give us enough time to decide to testify. You didn't let in the things we asked you to let in. We didn't have time to talk to this witness. I imagine it's going to be the same kind of thing that we have already seen her argue about, right? So, defendant's motion for new trial and leave to interview jurors. Defendant, Donna Adelson, through counsel, pursuant to rules, numbers are listed on screen, requests the court grant a new trial and states as follows. A jury convicted Ms. Adelson as charged in the indictment September 4th, 2025. This motion is timely filed within the first 10 days of the rendition of the verdict. I love that it's a 10-day rule. I love it. I love that it's a 10-day rule because it just gives so much, like if you're making the motion, just make it, well, it's fresh in everybody's mind. Love it. 3, Adelson requests leave to interview juror number 5 and juror number 7. I'm sure we'll find out who those jurors are. I'm guessing those are the jurors that have spoken publicly. I can't imagine they would have cause for any other jurors. I just don't know which one's which. And then 4, Adelson files this motion for new trial on the following grounds. Juror misconduct. I'm very interested what they think misconduct is. Verdict is contrary to the law or the weight of the evidence. Okay. 3, the court erred in a decision of any matter of law which arose during the trial. I mean, that's basic grounds for all of these motions. And then for any other cause not due to Miss Adelson's fault, she did not receive a fair and impartial trial. It's like, etc. Your Honor, and just reasons that aren't her fault. Motion for leave to interview jurors. The title has a footnote. Footnote 1. Although the jurors have identified themselves through social media or media appearance, the court previously ordered the parties to refer to the jurors by their juror numbers. I mean, that's fair. So, Your Honor, we're not referring to the jurors by name. You've asked to refer to the jurors by number. We're referring them by number. Fine. Fine, that makes fine. I don't think that's the right place for that footnote. Like that. I am not an English major by any means, but I feel like footnote 1 should have gone under number 3, Adelson's request to interview juror 5 and 7. I think the footnote just would have gone there because then it describes why you're calling them 5 and 7, but whatever. It's on the title. Paragraph 5. In the court's preliminary instruction to the jury, the standard instruction was read. You are not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, or even your fellow jurors. No communication includes no in-person telephonic or electronic communication, such as emailing, texting, posting information on social media, or a website, or any other form of communication. Right. You can't communicate about the case. Fair. I saw a great question I wanted to grab. Oh, Dreamscape said, will there be a state response? Yes, the state will file an opposition and then there will be a reply. And then there will probably be a court date set to argue this in court. I imagine the court's not just going to rule on the pleadings. So, the English teachers agree. Thank you. Thank you. Look, I just need the validation. It seems like I mean, I can't go by vibes, but also the footnote placement should be all of you are saying with the first mention. Thank you. Outside the box said 5, 6, 7. No, 5 and 7. There's no 6, 7. There's no 6, 7. There's no 6, 7. All of you are like 6, 7. Don't tell my 13-year-old I literally can't. I can't with 6, 7 anymore. Some of you are saying 6 also spoke out. Oh, damn it. We are actually at 6, 7. No, not the 6, 7. All of you in the chat who are just like 6, 7. I'm sorry. And all of you who are like, I have no fucking clue. Just 13-year-old junior high Gen Alpha skibbity whatever. 6, 7. That's what it is. All right. So Rachie71 said, during the trial, after the trial, can you talk? Yeah, they can talk after the trial. And I didn't see any information that the jurors spoke about the case during the trial. If that's true, I'm interested to hear what they have to say because that should follow next, right? The next sentence immediately says, subsequent to trial. Okay. Elizabeth said, must check with my Gen Alpha minion. You just say so 6, 7 and see what happens. I would just be like, just casually drop 6, 7 and see what happens. Subsequent to the trial, juror number 7, 6, 7, went viral on TikTok. Did it go viral, Chad? I didn't look. I just covered what we covered. So I didn't look for relative virality. So if any of you are on TikTok, are we talking like 10 million plus views? What are we talking about? Anyone who knows, just let me know. Juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. She's allowed to do that. A lot of you are saying it didn't even hit the millions. Okay. So what do they mean by viral? All of you are like, no, it definitely didn't go viral. She posted and people talked about it. Does not equal viral. But in her TikTok, she revealed that she posted to TikTok during the trial. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was elected as a juror on August 26, 2025. You're allowed to say that you're on jury service. I have not seen this TikTok. So just asterisks. I have not seen whatever TikTok they're referencing, and lawyers are going to take everything in the light most favorable to their client. So anything that the lawyers say, they're going to say in the way that gets them closer to what they want. So just take it with that information that this is advocacy. What I will say is that if you come home, you're allowed to come home and be like, yeah, I'm on the jury. You're allowed to call your employer and be like, hey, I'm going to be on jury service. And if you post frequently on social media, I don't see anything improper about saying, hey, chat, I'm going to be on jury duty, so I'm not going to be posting a lot. There's nothing wrong with that. So the juror posted on August 25th that she was selected as a juror. With nothing more, that's not improper. A flash drive with this video will be provided to the court as the undersigned has been informed that particular TikTok was deleted by the juror. Well, that's frustrating, but that actually might be grounds to have an interview if it's since been deleted, to ask, what did you post to social about this case? Because you're not allowed to talk about the case. Saying you're a juror is different than saying, oh my God, I'm a juror on the Donna Adelson case. Follow for more. Follow. You guys have to follow along. So a lot of you are saying the TikTok wasn't deleted. Oh, we'll go take a look at the end of this. Thanks. A lot of you are saying it wasn't deleted. We'll go look. We'll go look and see for ourselves then. Thank you. And some of you are saying she said she was a juror, but not what case it was, which is fine. All of you are saying it was not deleted and that you've recently checked. Great. Chat is bae. Chat has done the research. We'll go grab it at the end of this. You know how I feel about TikTok. If I switch off of this and go to TikTok, I'm just going to be fighting with TikTok for 25 minutes. So we'll do it at the end, so that the replay crew can look at the timestamps of Emily versus TikTok and goes, I'll just skip that. But saying you're a juror on the case is fine. And all of you are saying it wasn't deleted, so fine. The undersigned seeks to interview Juror 7 concerning her social media activity during the trial. Without more, that's not going to be enough. Although juror number 5 appeared on the podcast Surviving the Survivor, or additionally, sorry, not although, juror number 5, you're allowed to go on a podcast after the trial. During his appearance, he revealed he considered how Ms. Adelson reacted to the evidence and testimony admitted during the trial. Footnote 2. Based on the court's numerous admonitions to Ms. Adelson during trial, she was prohibited from expressing any emotion during the trial. Okay. Crystal in the chat asked, is it not the TikTok you watched last week? I didn't go back to August to see any video where they said that they were selected as a juror for jury service. I only saw the one where they were like, hey, the trial's over. I'm the Fore person. Let's talk about it. And I saw all of those. But I didn't see anything. I didn't go back and look at anything before that. I didn't go through their entire account. I just went to that one and forward. But let's continue reading. The next sentence says, although he subsequently stated he, quote unquote, obviously did not consider that during deliberations, that he considered Ms. Adelson's reaction whatsoever as concerning as her reactions were not evidence and are extrinsic or external rather than that which inheres in the verdict. So what you're saying is he revealed that they say the word considered. I'm going to go with noticed. They're arguing he considered Ms. Adelson's reaction to the evidence and testimony, though said he obviously didn't consider it. If he said in the interview he obviously didn't consider it, why is your argument he considered it? Even in the next sentence, you're undercutting your argument. Noticing and considering aren't the same. The fact that the defense immediately has to walk it back and say, okay, but he admitted that he obviously didn't consider it during deliberations, then he didn't consider it. Because it must be clear enough that the defense can't argue another interpretation. Because if the defense could argue another interpretation, they would. This feels like a stretch to me. Just their own, I have not watched this interview. Their own language feels like a stretch to me. He stated he obviously did not consider that during deliberations. Okay. Then he didn't. As a result, the undersigned seeks to interview juror number 7 concerning his consideration of Adelson's reaction to the evidence. He didn't consider it. You just said in the sentence above that he didn't consider it. And he said he didn't consider it. So what question are you going to ask him? Okay, in this interview, you said you didn't consider this. So you didn't consider, they just want to cross-examine a juror to try to find anything. That is not proper grounds, I don't think, to interview a juror. But they're going to cite the law. So let's see what they cite for the law. Because they want to interview juror number 7 for saying that they didn't consider the reaction, but they noticed it, seems to be the answer. Juror misconduct. According to the Florida Supreme Court, quote, potentially harmful juror misconduct is presumptively prejudicial. So their standard is different than the standard in South Carolina. We talked about this a lot with Murdaugh. The standard is closer to the federal standard. Presumptively prejudicial. So the defense doesn't have to prove that it did cause harm. Here are the if first. If there is potentially harmful juror misconduct, then it is presumptively prejudicial. Prejudice doesn't need to be shown. However, how do they define potentially harmful misconduct? They go on to say a party seeking a juror interview, quote, does not have to conclusively establish that the alleged juror misconduct occurred and, quote, actually prejudiced the case. Rather, they're quoting case law on this, quote, it is only necessary that the party establish a basis for an inquiry or grounds the party believes may exist. Once in proper contact, that's the courthouse Becky situation, that's not here. Once improper contact or juror misconduct is established by juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. Where's the misconduct, though? If the juror misconduct is confirmed from the juror interviews, the undersigned will request leave to make more extensive arguments concerning why the juror misconduct in this case warrants a new trial. But what is the standard that gets you an interview? None of this talks about that. Where's the standard for when an interview is granted? Unless Florida is just like, yeah, sure, if you ask for it, you get it, but that doesn't seem right. But I guess we'll find out. We're going to have to wait till the state responds to find out what the standard is, because they didn't cite the standard to get an interview, only the standard to find misconduct and to throw out the trial and get a new trial. But you're missing a step. And then they've moved on quickly. Are you moving on so quickly because you're missing a step? Is that why we're moving on? So I'm very interested to see the reply to this. Verdict is contrary to the law or the weight of the evidence. Okay. The only avenue for judicial review of the weight of the evidence is by a motion for new trial at the trial court level. That means the judge who sat for the trial is the judge that considers this. Citing Robinson. In Robinson, the court stated succinctly, that. Quote, the rules of criminal procedure and the court continue to recognize the critical need for some form of discretionary judicial review to serve as a safety valve in those cases where the evidence is technically sufficient to prove the criminal charge. Excuse me. But the weight of the evidence does not appear to support the jury verdict. What? There's got to be more to that case law from 1984 and 1994. There's got to be more to that case law. Something is missing in this discussion, because if there's technically sufficient evidence, then you're not going to overturn anything. I need to see, what I would want to see is the case law that talks about this case law. But that's what the opposition is for. A motion for new trial requires a trial court to evaluate whether the jury's verdict is contrary to the weight of the evidence and to act in effect as an additional juror. That is the Tibbs case from 1981. Okay. The standard is different than the one used by the court in ruling on a motion for judgment on acquittal, which utilizes the sufficiency of the evidence standard. And that is coming from a 2013 case. The sufficiency of the evidence standard, I'm diverging from what they've written a little bit, is at the end of the people's case, at the end of the prosecution case, is there enough evidence that a reasonable juror could find this person guilty? Is it sufficient? They are saying that this standard is kind of close but different. So we will see how that goes. But yes, sufficiency is what matters. I guess what they're trying to argue that they haven't expressly stated yet is that when you get to the end of the Commonwealth, we're not in Massachusetts, Emily, when you get to the end of the state's case, is there enough for a jury to find her guilty? And then when you get to the end of the trial, has the defense moved the ball back the other way, that when you evaluate the defense case plus the prosecution case, now there's not enough evidence. So it's adding the defense case into the consideration in addition to just the sufficiency of the state's case. They haven't expressly stated that, but that's where I think we're at. So they're stating the law. I guess we'll see what they're arguing the basis for this is. They're stating the law first. They go on to say Florida courts have held multiple times that when considering a motion for new trial under Rule 3.600A2, based on a claim that the verdict is against the weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. So this is really how much movement did the defense argument make? And in a case like, and I say Commonwealth because Karen Reed's obviously on my mind, but in a case like Karen Reed, I think the defense, in more than most cases we've watched together, the defense had significant evidence that they were presenting that undermined the evidence presented by the state. And when you look at civil cases and you see two sides presenting, the sides are trying to negate the other side's evidence. That didn't happen in this defense. There wasn't evidence that when you looked at it, you went, oh, I believe this witness versus that witness. Like when you looked at the experts in the Reed case, there were times where there was expert A and expert B, and you're like, oh, what expert B said makes so much more sense than what expert A said. Like, you can't undo that. But here, the key takeaways for me from the defense witnesses were that perhaps the friend gave Donna the idea to just buy a one-way ticket. And Donna was like, okay, bet. However, that doesn't change for me the Google searches. Like, it being a one-way ticket's an issue, but the Google searches are more of an issue than the one-way ticket. Like, if she had gotten a round trip, would you think she was coming back? After the Google searches, chat, let me know. After the Google searches, if she had bought a return trip ticket, would you have been like, oh yeah, she's totally coming back? Or would you be like, oh, she just doesn't want it to look bad? How would you see that? Because then there's also the selling the stuff, the I have to talk to you, the, I need to get this settled. We need to take care of Charlie's kids. And that's before you get to her own words in that call. Oh, and then the text. I know I'm next. I had forgotten about the text. I know I'm next, but I'm going to make sure that doesn't happen. If you stacked up a round trip ticket, the Google searches, the phone call, and then the I know I'm next, but I'm going to make sure that doesn't happen, are you assuming she has any intention of coming back? So her friend moving the needle on whose idea it was to get a one-way ticket does leave questions on the ticket, but the ticket isn't the only piece of evidence. All of you were like, and the rushed visa and the bury me in the dress. And right. The one-way ticket isn't the only thing. What other witnesses did they have? The friends were just like, Donna's a great friend. Okay. And then the divorce attorneys. Like, the divorce attorneys are like, it wasn't contentious. Sure. It wasn't maybe the most contentious, but it was definitely contentious. What else did the defense present? So there's that. All of you are like, don't forget the business and the canceling insurance and the selling things. Right. Right. So this isn't a case where I saw the defense evidence make a lot of headway. I don't think the defense evidence changed the state of the state's evidence like it did in the Reed case. All right, let's continue. The defense states that under Veloso versus State from 2013, the standard on the motion for new trial is different than the one used by the court on the ruling for motion for judgment of acquittal, which utilizes a sufficiency of the evidence standard. We just soliloquied about that. Florida courts have held multiple times that when considering a motion for new trial under Rule 3.600, based on a claim that the verdict is against the weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. Did we all watch the same trial? The weight of the evidence was not on the defense's side. For me. They go on to say the trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. When determining the weight of the evidence, quote, in essence, the trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. See State v. Hart, 1994. The role of trial judge in passing on motion for new trial on the, this is an awkward sentence. The role of the trial judge in passing on motion for new trial on the ground that the jury verdict is contrary to the weight of the evidence is to weigh all of the evidence and determine credibility of witnesses so as to act in effect as an additional juror. They have an entire page of saying nothing. They restated the case law in not even different ways. So for all of you that are like, Emily, did you lose your place and just repeat things? No. No, that's how they wrote it. Count 1, first-degree murder. At this stage, the court must make a finding that Patricia Bird was credible before considering Miss Adelson's alleged confession to Bird. Chat. Was Donna saying to Patricia Bird something that you considered, or did you forget about it because of everything else? I don't even think the prosecution really argued it in closing. They talked about the script. They barely talked about Patricia Bird. Like when we heard it, I was like, oh, that's interesting. And then when the script came out, I was like, fuck. And then the Patricia Bird stuff kind of got lost. The script is a different one. Patricia Bird was the first one that testified that was offered land, and Donna said, well, they said, like, I did what they said, but it wasn't supposed to go that far. She was that one, the first one. The script was the second one. I was surprised, honestly, that the defense didn't lean into Patricia Bird. I think if I was the defense, I might have leaned in and have been like, right, she said it wasn't supposed to go that far. She didn't intend for a murder to happen. She didn't intend for any of this. She asked Charlie to take care of it. She thought that Charlie would get Wendy to like fight more in the divorce, or she thought Charlie would get Dan like to talk to Dan and get Dan to back down and understand that they needed to take the kids. Like when she thought Charlie was going to take care of it, she never intended that take care of it meant murder. She thought because Charlie had a way with getting Wendy to do what she wanted, that Charlie was going to get Wendy to fight more in the divorce. I think I would have gone the totally different way on this, but this is why I could never be a defense attorney. Because what the defense attorneys have to do is sit with their client and say, I want to argue this. And then if their client's like, we're not doing that, you really have to work with your client on a case. I would really want to be like, I'm sorry, I'm the lawyer, I get to make these choices. It would be very hard to try to get Donna on side. But I imagine even if the defense said, I think we should lean into this isn't what was meant, they have to have their client on side. And I imagine that Donna was not on side. But I thought that in closing, we would have heard more about, I mean, yeah, I wanted Charlie to help because Wendy, based on the emails, I think there's an argument there that Wendy was pulling back from fighting on the divorce, and Charlie take care of it was, you know, get Wendy to act right. I think there is an argument there. And then you attack that she didn't drop off the money. But then the checks kind of bite you in the ass, don't they? The checks from the dental office. Those checks really, those checks will come back and get you, right? But I could see Donna turning around and arguing something like, oh, I thought Charlie was just kind of paying her off for his dalliances or something. I didn't know what Charlie was up to. Charlie doesn't keep it in his pants. Like I thought it had something to do with something else. I wasn't really asking. Because Charlie was being all Charlie. And the money drop, though, I found the testimony about that to be really credible. The testimony about her being there and the damp dollars, I found that really credible. So it kind of throws a wrench into that defense, but I think it's better than, you know, well, she would have argued. And then he was being extorted about the thing. But it would be an argument against, and the defense's best argument was against that she knew what was going to happen beforehand. That was the defense's best argument. Their best argument was she had no idea what was happening. But then there's the bump. You guys are right. The TV's about 5. Her behavior at the bump shows she's not freaking out. She's not like, what the fuck have you done, Charlie? She never says that. She never once says, Charlie, what the fuck did you do? Because she knew. I mean, you're right. The bump makes it real hard. Jen in the chat said one damning part to me was the PI who said he was specifically told not to record the interviews with the jail informants. The defense witnesses were horrible for them. It's a very good point. I thought that's why the defense took the lesser off, because it would have given the jury an out for murder 1 if it wasn't intentional. Yeah, it would have. And yes, murder 2 wouldn't have needed intent. But then they didn't argue. They didn't argue enough about the intent in closing. So, Lucy said the FBI wound a key and Charlie just went off chatting nonstop. They did. I would be so curious to hear about how they profiled him. Maybe we'll get that information somewhere down the road, but I'm curious to hear about how they profiled Charlie, because they, like a junior high school mean girl, they innately knew exactly what buttons to push to wind Charlie up. And going to his mom, he's like, why would they talk to her and not talk to me? They just were just like, they pushed all the buttons. I don't know how people do that. Most of my conversations are like, I'm probably talking too much. I should stop, but I can't. Did you see that every single performance of the Long Live the Black Parade tour was different? It's basically a T-Swift level Easter egg concert, but for emos. It was fantastic. Did every single one was different? Can we talk about that? No, I should probably stop talking. Nobody cares that much. That's how my conversations go. It's never looking at the person across from me going, how do I just push their buttons? It's never that. That's never it. That's never it. And then at a lot of the YouTube events, somebody would come up to me and be like, hey, can we talk about Donna? Fuck yes, we can. Occasionally it's like, hey, I know that this is your like content, so you might not want to talk about it when we're like at a social event, but can we talk about Donna? And I'm like, the thing about me is I am very neurospicy. So I do not talk about cases that I am not prepared to talk about at all times, no matter where I am with everyone. So if you mention anything I'd covered, I am going to talk about it. Just tell me when I've gone too far. Tell me when we've talked too much. just let me pause, because I'll just keep going. If you get bored, just tap me on the shoulder and be like, yeah, I got it. All right. I don't understand how they profiled it, but they did such a good job. So at this stage, they say the court must make a finding that Patricia Byrd was credible before considering Adelson's alleged confession to Byrd. I don't even think they need it. Under no set of circumstances can Byrd be considered credible. I don't think they need it. I think you take that information out and it doesn't even matter. I don't think Byrd's testimony was interesting to me. I do not think it makes or breaks the case in any way. It's added icing. It is not the foundation of this case. Even if the court said we don't find Byrd credible, it changes nothing. The defense goes on to say, under no set of circumstances can Byrd be considered credible. She testified the defense investigator with whom she spoke was a white woman. Ms. Khan was obviously not white. Okay, but the male investigator was. And she talked to numerous investigators. Am I all that flustered if she wasn't sure which one she was testifying to? If it was Byrd alone, it might be different. But when you have Byrd and then Bernhardt with the script, you got me. You got me. I think Byrd supported the testimony of Bernhardt and bolstered that testimony. Because the way Donna tried to manipulate them was very similar. And I think based on all the testimony that Donna 100% said to her lawyers, go talk to Bird, she'll tell you what we need, very walk the dog style. Go talk to Bird, she'll tell you what we need. And Bird's like, I'm going to give you the script, the verbal script. I'm going to tell you what Donna told me to say. It's so fucking walk the dog letter. Corey Richins in her walk the dog letter says to her mother to tell her brother, so there's like these steps of deniability. Tell him my defense attorney needs a connection between this and this and that. Go tell brother to go tell my lawyer that he's the connection. This is the same shit. Hey, defense attorneys, Patricia Bird knows the truth. Come interview her. And then we'll turn it over to the state. She'll be our witness. And then they never turned it over to the state. Wonder why. Big mystery. I just am so curious about what happened in custody to change the relationship with Bird and Bernhardt and Donna. And if whatever went down with all of them is around the time that Donna came into court crying that she needed to be released from custody and that people were extorting her for commissary. Because after seeing all of this, I think that no one was extorting her for commissary. I think it was payment for testimony. What do you think? And I think Bernhardt matters more. Okay. She further testified that she told both Mr. Varnes and Ms. Kahn that Ms. Adelson confessed and that Ms. Adelson offered her financial incentives in exchange for perjured testimony. Both Mr. Varnes and Ms. Kahn dispute those claims. I don't remember that testimony. I thought, and you let me know if I'm remembering it wrong. It's been a very busy 2 weeks. I thought that Bird said that she told the investigators what Donna wanted her to say, and then she told the state investigators what the real was. Like, no, I told them what Donna told me. And then I told the state investigators what she offered me. That's how I remember it. I don't remember it the way they're writing it. It goes on to say she further testified. Oh no, additionally, Ms. Kahn testified she never met with Ms. Adelson. So, what the fuck does that have to do with literally anything? Additionally, Ms. Kahn testified she never met with Ms. Adelson. So, thus, unless the court were to believe defense counsel conveyed to Ms. Kahn that Ms. Bird was to be offered money for testimony, Ms. Bird's testimony should be disregarded completely. I think they've got it twisted. I think they are completely forgetting Bird's testimony, but Miguelina, can we, in the description, just link the day Bird testified so you guys can go to the timestamps and take a look for yourself if you're curious? That's how I remember it. Ultimately, I don't think it matters. I think the testimony of Bernhardt matters more. And they're going to attack that next. The same is true of Drina Bernhardt. Ms. Bernhardt's motivation to lie was, they say, and is significant. With 27 felony convictions and facing a mandatory 15-year prison sentence as a prison releasee reoffender, Bernhardt's credibility was significantly impeached. Except she wrote it down. That was Donna's damn handwriting. And And let us not hold on, chat. Let us not forget what we have not talked about yet. Do you remember Wendy testifying that her mom tried to influence how she would testify at Charlie's trial? Are we to believe that this is out of character for Donna? That she's telling someone what to say? Because she told Wendy what to say at Charlie's trial. And then we've got her telling Charlie different things. And then we've got Charlie doing the exact same thing to Catherine McBanawa at that restaurant meetup going, okay, so what you're going to tell them is exactly this. And then you've got her following out the exact same behavior with the two in custody. It's the same behavior. Donna's like, say this. And they're like, nah, we're done with you. I don't know why they're done with her, but they're done with her. I'm curious as to what happened. But they're done with her. The same is true of Drina Bernhardt. They say Bernhardt's motivation to lie was and is significant. They go on to list, now I am repeating myself because I lost my place. The only one who testified this was Miss Adelson's words rather than Miss Bernhardt was Miss Bernhardt. That's just not true, counsel. Counsel is trying to look at these things not as the totality of the circumstance. But if you take what Wendy said, what Bird said, and what Bernhardt said, the three things together lend towards this is what Donna's doing. And a reasonable jury can make that inference. No one said that those weren't Donna's words. In fact, the defense stood up. It was stricken from the record, but the defense stood up and said, we're not contesting that that's Miss Adelson's handwriting. Also, fucking miss me. Oh, miss me with the fact that Drina Bernhardt is sitting there in jail going, oh, and then Catherine McBanawa said, that silly fool. Fuck you. There's no way. There's no way. Emily, are we going to rant again about the fact that Catherine McBanawa would literally never say that stupid fool? Correct. But you know who would say that? Donna. Because Donna's bestie got up and testified. And what did she say Donna said about something? I think it was about the horrific emails that Donna said that was foolish of her. Donna's words. Donna's the one using the word foolish. Not Catherine McBanawa and not Drina. It's just a linguistic difference. And it's generationally appropriate that it's a linguistic difference. But that fool, mwahahaha. No, if Catherine McBanawa is saying anything about Charlie Adelson, she is saying that stupid motherfucker. Fuck him in his fucking face. That's what she's saying. I took his money. Hey, dirty, baby, I got your money, said, hey. Yeah, she's never saying that fool. Oh, jeez. All right, so no one ever said that the script was in Donna's words, even though it was in her handwriting as the defense's next argument, because they have to do their job, I suppose, and they've got to come up with arguments. This is just the arguments that they're coming up with. Linda in the chat said also having Katie literally say, I extorted him. Yes, underlined and italics. Even people who are doing extortion crimes oftentimes aren't calling it extortion. Emily, you enjoyed working in in this type of crime. Yeah, fraud stuff was my stuff. Most people don't know the difference between extortion and blackmail. So I wouldn't expect someone to make that distinction. And didn't we have a Google search? We did. Emma Mack in the chat said, and Donna had to Google the difference between blackmail and extortion. Yep. But Donna's never been in custody. That's why Donna doesn't know that that's not how people talk. All right? Drina's been in custody. Drina could give you the jail lingo that Catherine McBanowa would have more likely used. It would have been the more appropriate slang. This was not written that way. Oh boy. The surveillance video admitted into evidence establishes that Drina and Miss Adelson worked together to write the quote unquote script. Nah. Excuse me. The theory of the state's case was that the defendant is guilty as a principal to the charge of murder because she agreed to the plan that was carried out by her son, McBanowa, Garcia, and Rivera, and she paid for the crime to be carried out. I mean, that simplifies it. There is no evidence that Adelson committed any act or uttered any words in furtherance of the offense prior to it being completed. And for that reason, the evidence is not sufficient to support her conviction as a principal of first-degree murder. It's going to be interesting to see the state lay out all of the different ways that Donna was connected to this, but some of it is circumstantial. It's allowed to be circumstantial. And so we're going to see the evidence before, and we're going to, I think, see the state argue that Charlie telling Catherine McBanowa, this has to be done, it's causing too much stress for my mother, the diarrhea Donna of it all. It's causing too much stress for my mother. Like, this has to get done. It's causing so much stress. Indicates that Donna was having those conversations with Charlie beforehand. There was no wiretap. We don't know what was said on the phone. But we know what Charlie told Catherine McBanowa, if Catherine's believed, and they don't mention that testimony in here at all. And if it's believed that Donna brought over the money because Charlie told Catherine McBanowa that, if you believe that that's what Charlie told Catherine, then she's paying for it. If you don't believe that Charlie's telling Catherine the truth, and you just believe the checks that are being written by Donna, I think most believe Rob Adelson's testimony. And Rob said, yeah, my mom's not going to just write checks out of the dental office without knowing what it's for. And that also goes to knowledge beforehand. But that is circumstantial. But as it is in most conspiracy cases, I saw a couple questions in the chat, and Kimberly, I'm going to pull yours up, but I saw a couple questions in the chat. Who will rule on this? The trial judge. This goes to Judge Everett. And then if Judge Everett denies this, then that decision gets appealed. If Judge Everett grants this, then there's a new trial. Or Judge Everett can go in between and say, yes, let's talk to the jurors. But I think that's improbable. But we'll see. They go on to say, although a person can be convicted as a principal to a criminal offense based on words alone, there must be competent, substantial evidence these words were spoken in advance of the crime. A person can be convicted as principal to a crime under Section 777.011 Florida statutes only if there is evidence that they committed some act or uttered some words to assist another in the commission of the crime when the crime was being carried out. Bringing the money. bringing the money. They're not arguing about bringing the money. Have they said it once? The elements of the crime are set out in the leading case of Statine, S-T-A-T-E-N versus State. Quote, this is a 1988 case. In order to be guilty as a principal for a crime physically committed by another, one must intend that the crime be committed and do some act to assist the other person in actually committing the crime. Bringing the money would be an act. But when we look at Harvey Adelson or Wendy Adelson, this is what needs to be kept in mind. And I think we learned more about Wendy in this last trial, but I don't know enough about Harvey before the fact. After the fact, we can talk about, but before the fact, no. As acknowledged previously, intent is an operation of the mind and may be established by, what does it say, chat? Circumstantial evidence. There certainly is no direct evidence that Miss Adelson intended for Mr. Markel to be killed. No, her direct words are psychological torture. Her direct words are about tormenting him. However, the defense argues there is also no circumstantial evidence that Miss Adelson wanted Mr. Markel to be killed. Even if there was, there is no evidence to establish the second element that she did, quote, some act to assist the other person in actually committing the crime. McBanawa testified per Charlie Adelson, his parents stopped by his residence on July 18, 2014, after Mr. Markel was murdered. However, McBanawa did not testify that Miss Adelson or her husband dropped off any money that night. And the state expert agreed the state could not place Miss Adelson or Dr. Harvey Adelson's handsets at Charlie's residence July 18th. Her text messages said, "We're here though." Like, I'm here. Also, Wendy Adelson called fairly late in the day and told Donna that Dan Markel had been shot. And then Donna immediately is rolling up to Charlie's place with money. There's no time to negotiate what we're doing. It's like the plan is already in action. It's like they discussed it beforehand. It's like they knew what needed to happen on what day. Thank you. Outside your house was the direct quote. Thank you, chat. Jesse in the chat asked, wouldn't writing the checks be an act of assisting the action? The writing of the checks was after. So what would point to the fact that they agreed before? I think them showing up at Charlie's with the money the same day indicates that they made an agreement before. I think knowing Dan Markel's schedule, to me, there's enough evidence that a reasonable jury can infer that the way they knew where everybody was going to be and where Dan Markel was going to be was through Donna. I didn't see any evidence that Dan Markel's schedule was known to Charlie Adelson because of Wendy. It seemed that those discussions went from Wendy to Donna, Donna to Charlie, Charlie to Katie. So Donna giving Charlie the information about Dan's whereabouts because Rivera said the guy's going out of town the next day. How did Charlie know that? Donna's the one who kept detailed records of Dan's travel. That information is getting to her from Wendy, but Donna has that information. And who's Donna talking to? Charlie. Wendy's not giving that information to Charlie. Telling Charlie where Dan Markel is going to be so that Rivera knows the guy's going out of town the next day, it's got to be today, is circumstantial. But it doesn't make it not evidence. And all of you are like, and she had his license plate in her planner 2 years after the divorce. So I think there are some solid arguments. Okay. I'm interested to see how the state argues that in their opposition. They go on to say, McBanawa did not testify that Donna or her husband dropped off any money that night. But maybe it'll come up later. They're leaving out that when Katie asked Charlie why the money was musty, Charlie said, my mom washed it. That fool. Those were my words, not his. Even if Miss Adelson and Dr. Harvey Adelson did stop at his residence, it would have been approximately 9 hours after Mr. Markel was shot. They're leaving out when Wendy called, because I think that was around 7 p.m. So it was about an hour, give or take, after they learned that Dan had been shot. It was not 9 hours after they had knowledge that the shooting happened. So there's a lot of information that the defense is just leaving out. All right. Also, the parent text messages, the we're outside, the my parents just left. It's circumstantial, but circumstantial evidence is evidence. You know why? Because people don't always directly talk about their crimes. I mean, sometimes they do, but often they don't. They try to use code language. The defense goes on to say, in fact, at the state's request, the court found that Donna Adelson had adopted Charlie Adelson's prior testimony. This included Charlie's testimony that he paid McBanawa from his own money, which he kept stapled, as confirmed by McBanawa, Fitzpatrick, and June Umchenda. I think so. June, the cheerleader. Charlie's testimony also included the fact that he did not tell Donna he paid McBanawa for the shooting until September 17th, 2014. No evidence was presented that Miss Adelson was aware of anything other than Mr. Markel had been killed prior to September 17th, 2014. The defendant in the case law above, Staten, drove the perpetrators to the scene of the crime, waited across the street while they were committing the crime, and then drove away in the car. In these circumstances, the jury could legitimately infer that the petitioner was a participant in the crime, and thus the Supreme Court concluded that the evidence supported the defendant's conviction as a participant. Affirmative acts such as these are common in prosecutions under the principal statute. True. Writing for a unanimous court in Ammons versus State, Judge Brad Thomas, that's funny. I know a Brad Thomas, not a judge, but I know a Brad Thomas. Surgeon. Explained the rule as follows. To sustain his conviction as a principal, the state was required to establish that the appellant, quote, intended that the crime be committed and do some act to assist the other person in actually committing the crime. The judge in that case noted that he was emphasizing the phrase do some act in the quotation to explain why the court was reversing the defendant's conviction. Although there was evidence that the defendant intended to participate in the crime, there was, quote, no sufficient evidence that he did some act to assist in the commission of the crime. In this case, as in Ammons, there was no evidence that defendant, quote, did some act to assist in the commission of the crime. The most the evidence shows is that she knew of the plan at some point. That is not sufficient under the rule. This is part of their grounds for appeal. And I imagine that when this is denied, we will see that this line of argument will come up in appeal. What did Donna know before the crime went down? And that's where I think we will see the state argue about the Evite, that Donna was already referring to the kids as Adelson, not Markel, because she knew the murder was coming up. That Donna wanted to talk to Charlie secretly about the birthday party, because in talking about the birthday party, they wanted to make sure that everything was on the low. And she told Charlie, delete this text. We need to talk about it. And we need to talk about it when I'm not around your dad, right? About the birthday party. And Rob Adelson was like, at this age, the birthday party wasn't really a secret. It was the whole family getting together. So I think we'll see the state make some of those arguments, because there is behavior from which circumstantial inferences can be made. All right, the defense goes on to talk about other rulings, including the ruling in Williams. So we're going to take a look at other case law here that the defense is pointing out. This is quoting the Williams case, saying, quote, even taking a broader view of the murder of Mike, for all of you listening in the background, we are switching to case law. This is not this case. This is case law that's being argued. Because some of you are going to be listening and go, wait, who the fuck is Mike? Mike. Totally different case. In Williams, the court held that, quote, even taking a broader view of the murder of Mike, the scheme that preceded his death, whereby Denise was to make sure Mike went on a trip with Brian. Why is there always a Brian? For all of you that just came in to be like, thank you, I was listening in the background and I was exactly like, WTF are we talking about? Damn it. I'm gonna have to make a note. Like, what were Denise, Mike, and Brian doing? I feel like we're not going to get the whole story from these quotes. We might have to tangent and figure out what happened with Mike and Denise and Brian another day. Taking a broader view of the murder of Mike, the scheme that preceded his death, whereby Denise was to make sure that Mike went on the trip with Brian, there was no evidence regarding what she did rather than what she was supposed to do in furtherance of the scheme that day. As we have explained, proof of the conspiracy alone is not enough. Agreeing with someone to commit a crime or developing a criminal scheme with someone else by itself does not establish that the person assisted in the eventual actual commission of the underlying offense. At a minimum, there must be proof of some overt act or some words uttered in furtherance of the scheme that led to the murder. The state offered no such evidence at trial. So this is case law that is on their side. That they are saying, look, in that case, Denise was supposed to get Mike to go on a trip with Brian. The case law they're citing seems to indicate that Denise said she was going to do that, but didn't. Or there's no proof that she did or didn't. The case continues. And they continued the quote without capitalizing the first. Okay, Emily, let it go. Quote from the Williams case. There still needed to be evidence of what she did to assist Brian as the offense unfolded. There was no testimony that Denise assisted Brian at the lake. Oh, there's a lake involved. There was no testimony that Denise assisted Brian at the lake as the murder happened, nor any testimony that Denise was on the phone with Brian while he was at the lake with Mike, goading or encouraging him to go through with it, or giving him advice or guidance on how to pull off the murder when things were not going as they originally had planned. Wait, something went wrong? In fact, there was no testimony about anything Denise did, any acts or words uttered to facilitate the offense, to encourage the offense, or to direct the offense at any point during that fateful day. Well, did she get him to go on the trip? I don't know. Jesse said, wait, is this the Gainesville murder case where they said a gator wouldn't eat him and it turned out a gator ate him? I don't know. Dreamscape said Denise did encourage Mike to go, but their plan was that Brian would push Mike overboard and God would take care of the rest. Brian played God and shot Mike in the face. Denise had not agreed to that. Oh, shit. Well, thanks, chat. Wait, there's a Hulu case about this? Okay, we definitely need a side quest. Kimberly said this is Gainesville, or not Gainesville, also Tallahassee. There's a Netflix show about it called Mr. and Mrs. Murder. The case is Mike Williams' death that went unsolved for a long time. Okay, we're going to side quest a different day. Thanks, chat. This is a worthy side case. Brian was Mike's BFF and was having an affair with Mike's wife. Well, it definitely seems that people aren't happy. Look at this. Thank you, Brenda. Look at all of this. All of you are just like, yeah, this case was on Netflix and it's being quote, look, case law and binding precedent can be interesting. All of you are saying this case is a whole thing. Do we need a podcast episode or a stream on it at a minimum? We totally do, right? I'm making a note. I'm kind of bummed we can't do it today because I'm like, I need to now know everything about Denise, Brian, and Mike. All of you are saying we need to do a stream on it. Oh, for sure. Okay. 1010 chat, I hear you. All of you are like, we definitely need to talk about it. Because now I'm interested in the case law because they're saying that in that case, the court said that there's nothing to connect Denise to what went down that day. And they are likening that to Donna, and Donna not doing anything to encourage it that day. So to just repeat what the court said before we side quested, in fact, there was no testimony about anything Denise did. Look, if any of you have any takeaways from today, you really need to trust anybody you be on a boat with. Especially if you're out in like Everglades. Just make sure you know who you're boating. Make sure you know who you're boating with. Just bad shit happens. Red Hot Amy Kate immediately said, we're going to need a bigger boat. Yep. Oh my God, we're only on page 8 of 18. Emily, keep reading. All right. In fact, there was no testimony, the case law says, in the Williams case about anything Denise did, acts, or words uttered to facilitate the offense, to encourage the offense, or to direct the offense at any point during that fateful day. So they are leaning in case law, talking about the day of the crime. To be fair to the defense making this argument, they are saying, look, what evidence do you have about what Donna did that day before the murder? They are trying to narrow the scope. But I think we have things Donna did leading up to that day. And I don't know if the scope of principal liability in Florida is so narrowed that it is just like the morning of. I'm curious about what other cases say about this case. But we're going to have to wait until the prosecutors tell us. I want to see how they argue the case law. Because I have Hulu shows to watch. Thank you, chat. We also have a podcast to record this weekend about something completely else. But this is we might have to do this on Tuesday. I'm really curious. Like, incredibly curious. Incredibly curious. The state may argue that Miss Adelson's act of delivering money to her son's house sufficiently establishes what she did the day of the murder. However, nothing about delivering money after the murder could support her conviction as a principal to the murder itself. So they're arguing that delivering money afterwards isn't enough. But wouldn't you have to arrange to bring the money before? Like, wouldn't that discussion have to happen? It goes on to say that additionally, there's no evidence of what Miss Adelson agreed to pay the killers prior to the fact. In fact, McBanawa testified during trial that the amount of payment was never addressed prior to the murder. Well, with her, but it's fair because I don't think there's any evidence that what agreement was made with Charlie and Donna prior to this either. But there's also the Best Buy appointment, right? I'm interested to see how the state addresses this point, because I think of all the arguments the defense has made, this is their strongest argument. They should have led. I'm always a big fan of leading with your strongest argument and then letting it kind of go as you get to the end. Because when you start with the weaker argument, for me, it makes me more skeptical of everything you're about to say next. Lead with your strongest argument and then just work down from there. But this is more of a appellate argument that we will see. Let's see. McBanawa testified during trial that the amount of payment was never addressed prior to the murder. We'll see. The state may also argue that Adelson necessarily provided Mr. Markel's tag number to her son, who gave it to McBanawa to give to Garcia Rivera. Right. However, there's no evidence the tag number was ever given to Charlie, let alone McBanawa, Garcia, or Rivera. Nobody knows. It's a fair point. A piece of paper with information was given to McBanawa. And then that was given to Garcia. And then Garcia and Rivera knew where he lived and what his car was. But there is circumstantial evidence that they know. So, even if such evidence existed, there's no evidence that this was done on or even before July 18th, 2014. No evidence was admitted during trial to establish the purpose for which Miss Adelson had the tag number in her 2014 planner. At least they addressed it. Finally, with respect to the second principal instruction 3.5b, there's no evidence Miss Adelson made any payment prior to the murder, or that she, rather than Charlie, promised any payment prior to the murder. At worst, even if Miss Adelson dropped cash off at Charlie's house after the murder and signed the payroll checks after the murder, would establish her culpability as an accessory after the fact, but are not competent evidence as principal to first-degree murder. Principal to first-degree murder and accomplice after the fact are different things. That's me interjecting. Moving on to count 2. Conspiracy to commit first-degree murder. The state's theory on count 2 was that Miss Adelson agreed with Charlie and others to kill Mr. Markel. As was clear throughout the trial, there was no direct evidence of Miss Adelson's involvement in the conspiracy the state proved as to Charlie, McBanawa, Rivera, and Garcia. You let me know if you agree with that. The primary evidence against Miss Adelson was, quote unquote, the motive. Miss Adelson desired to have her daughter and grandsons move to South Florida. Although there was certainly evidence that Miss Adelson was not happy with the way Mr. Markel treated her daughter in the litigation process, the non-contentious one, there was no evidence Miss Adelson said or did anything to suggest Mr. Markel be killed a year after relocation was denied and the dissolution of the marriage had been settled. There was no evidence Miss Adelson was even aware, according to Jeff Lacasse, that Charlie Adelson looked into hiring a hitman in the summer of 2013. How the hell would Jeff know what Donna knew? He only knew what Wendy told him. It goes on to say, to establish a prima facie case of conspiracy, the state had to admit evidence that A, the intent of Donna Adelson was that the offense of first-degree murder would be committed, which is why I think they should have argued as to Patricia Bird that she never intended the murder. B, in order to carry out that intent, Donna Adelson agreed, conspired, combined, or confederated with Charlie Adelson or Catherine McBanois or the others. Well, she definitely did that. The intent, I think, is their strongest argument. The undersigned asked the court to consider the evidence without the state's spin. So just with your spin, excuse me, Your Honor, can you please just consider it the way that we're asking you to? That's not the standard. That's not... Okay. Your Honor, don't look at it the way that they say to look at it. Look at it the other way. Look over here, over here, over here. Without the state's spin. You mean argument? You mean the state's argument. Without the state's argument. The jury can draw inferences from circumstantial evidence. But I think of all their arguments that we've seen, their argument about the strength of the evidence to show what Donna knew or intended or did before the crime is their strongest argument on these points. I don't think the jury, the juror misconduct argument, I'm not persuaded in any way. I was much more interested in what the jurors had to say in the Murdaugh case and in the Reed case particularly. I was much more interested in those. Your Honor, don't listen to the state. They're just spinning stuff. Certainly, they say Miss Adelson suggested crazy and offensive methods to her daughter to convince Mr. Markell to change his mind about relocation. At least they didn't back away from that. Once the dissolution was final on July 31st, 2013, what evidence exists that Miss Adelson continued to have a motive for Mr. Markell to be out of the picture? Parentheses. If we ignore the emails that she suggested her daughter ensure Mr. Markell be obligated to share expenses with her for their son's college education, all events which would necessarily take place after he was killed, ? What? There is none. Mary in the chat said, he is just relitigating. Yes, that is what this motion is for. That's what it's for. Where is the evidence Miss Adelson agreed, conspired, combined, or confederated with anyone else that Mr. Markell be killed? There is none. I disagree. The state's entire case is premised on speculation, impermissible stacking of inferences. I mean, the court already denied that, and theory. Without the speculation, theory, and impermissible stacking of inferences, there was no evidence Miss Adelson ever agreed for Mr. Markell to be killed. The things she did after the fact can be evidence of consciousness of guilt, so the jury can take a look at the rest of it. The evidence of flight was not... Okay. Don't argue with me over this flight, man. You were doing better. We're going to jump the shark or the pond in a minute here. The evidence of flight was not that she was fleeing to avoid prosecution, but that at the time in November 2023, she believed in her son's innocence and that if he were convicted, the state would next turn their attention to her. Rather than consciousness of guilt, that is evidence of her real fear the witch hunt would continue. Counsel, your client tried all of this. Tonks in the chat said jump the gator 100%. You guys tried this. You tried to have her friends illustrate this point, but Donna didn't say that. So there's no inference here that Donna was afraid of prosecution in a way that's not consciousness of guilt, but just like, I'm afraid I'm going to be prosecuted because I'm so innocent versus I'm afraid I'm going to be prosecuted because you know what it's about. It's about the two of us. The trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of the issue or the other. Although the fancy counsel for real. Although the fancy presentations prepared by the state may have been persuasive to the jury, Ms. Adelson asked the court to look objectively at the evidence, removing the improper stacking of inferences on which the jury's verdict is premised. Your Honor, those dadgum PowerPoints. It wasn't the PowerPoints. Also, the PowerPoints weren't that fancy. It was the Spider-Man meme that did it, counsel. It's not, I'm joking. It's the wiretaps, counsel. Your client is on the wiretaps. This isn't a jury that was just bowled over by a PowerPoint presentation. And given the fact that the jury resonated with the Spider-Man meme, I imagine that members of this jury have made much fancier presentations in junior high school as part of a report that they had to give. This was a younger jury. The fact that you put some technology on a timeline, which I thought was great. I thought it was a great presentation. It made the evidence easy. But it did nothing but line things out in a timeline. It was well done. That their fancy presentation just bowled over what? The simple folks, counsel? They can't look past a fancy presentation. Stop it. If you hadn't spent your entire closing argument screaming at them, maybe you would have made some more headway. Perhaps. Count 3, solicitation to commit first-degree murder. The state's theory on count 3, the defense says, was that Donna convinced her son to find someone to murder Dan Markel. At least they're not calling him Danny in the motion. The charge of criminal solicitation requires evidence that the person intends the crime to be committed and that she commands, encourages, hires, or requests another person to engage in specific conduct which would constitute the commission of the crime. Again, this is where I think they would lean into what Patricia Byrd said. I don't think with the weight of the evidence, a technical legal argument would have persuaded the jury ultimately, but I think it might have done more than just yelling at the jury to say, look, to really make them think, hey, what shows you that Donna wanted Dan Markel dead? Because Patricia Byrd came in here and told you that Donna said, yeah, I wrote the checks, but I didn't want it to go that far. It would have been a different argument. I don't know if it would have been a different outcome. But if you go with the technical, you have to prove that she wanted someone to hire Dan Markel. What do you think, based on this, shows you that she wanted Dan Markel to be hired or to be killed? They go on to say, as the jury instruction sets out, the state must prove beyond a reasonable doubt that Donna solicited Charlie or Katie McBanois or others to commit first-degree murder. What is the thing that shows you that Donna did that for you? During the solicitation, this is part 2 of the jury instruction. During the solicitation, Donna commanded, encouraged, hired, or requested Charlie or Katie or others to engage in specific conduct which would constitute the commission of first-degree murder. To, quote, solicit means to ask earnestly or to try to induce another person to engage in specific conduct. The evidence admitted at trial failed to establish that Adelson asked anyone earnestly or tried to induce anyone to murder Mr. Markel. I imagine what the state would say here is that when Charlie was relaying to Catherine McBanois, we have to get this done, this is stressing out my mother, and that Donna's like, I can talk to you about the party, delete the message, that those are the things showing she was having those conversations with Charlie. And then she's starting to refer to the kids as Adelson, meaning in her mind, she's already envisioning the kids without their father and without their father's last name. The defense goes on to say the evidence admitted at trial failed to establish Donna asked anyone earnestly. Rather, the competent, substantial evidence, I don't know about that, establishes that when Charlie was speaking with Katie concerning Dan Markel, he would at times make or receive calls from Donna. Katie did not testify to any messages Charlie conveyed to her, and Charlie, although transported from prison to testify, was not called as a witness. Charlie told Katie that this was too stressful for his mom, that this had to be taken care of. Donna had diarrhea. Katie testified to all of that. Needs to be taken care of. As with the argument concerning count 1 above, they go on to say that the evidence may have established her involvement after the fact. And her complaining to Charlie about how Mr. Markel treated Wendy, the fucking worst sentence ever. Hold on. I have to start this again. Because I was expecting it to make sense and then it jumped somewhere in the middle. Or I'm just really tired and undercaffeinated. As with the argument concerning count 1 above, the evidence may have established her involvement after the fact, and her complaining to Charlie about how Mr. Markel treated Wendy Adelson, there was simply no evidence she commanded, encouraged, hired, or requested Mr. Markel be murdered prior to the murder. No, that's the sentence. That's not me. I think, God, I think what counsel is trying to say is that Donna complaining to Charlie about Dan isn't evidence of encouraging that Markel be murdered. Good Lord with that sentence. Lawyers, hey, Grammarly is allowed. Like you can use Grammarly to help. I mean, not sponsored, that's Incogni, but you can use Grammarly to help like highlight that your sentences don't make any sense. Also, keep it simple. Like keep it simple. Just keep it, just break it down. When you don't have a strong argument and you can't articulate your argument well, we can tell. And if it hurts our brains, the court is sitting there going, ugh, stop. The motion goes on to say common sense and the plain, there's nothing in this that's plain language. Common sense and the plain language of 777.042 Florida statutes require the solicitation to be committed prior to the crime. Yeah, you can't solicit someone after the fact. With there being no testimony from any witness or any evidence admitted that Adelson asked anyone to murder Markel, the entire premise for her conviction on count 3 is simply speculation and, as argued in court, an improper stacking of inferences. For those reasons, Ms. Adelson's conviction on count 3 should be set aside in a new trial, granted. All right, we are done with the legal arguments. We are moving on, or done with the arguments about legal sufficiency. We are moving on to the defense arguing that there is error. So this is the third prong of their arguments. We're now on page 12 of 18. And the heading for this section is the court erred in decision of any matter of law which arose during trial. It's just so vague. The court erred in denying Ms. Adelson's request to admit into evidence the complete 2014 planner and 2023 planner. I mean, at least that's a specific ruling that we're identifying. I don't disagree. But at least it's a ruling. During trial, the defense sought to admit the complete planners to correct the misrepresentation expected to be made by the state and which came to fruition during the state's closing argument. They did, but there was no foundation for one of them at all. And the court's like, but there's no foundation. So you should have thought of that before. We can't admit something into evidence where there's been no witness to lay the foundation for it. The state argued that Markel's tag, and this is a typo, it's supposed to be Mr. Markel's tag number in the 2014 planner, was evidence that Ms. Adelson provided the tag number to the shooters, despite there being no evidence this happened. It was evidence that she had his license plate number 2 years after their divorce. So yeah, an inference can be drawn from that. Rivera testified that there were words on the photograph given to Garcia, but no evidence was offered what those words were. I agree with that. With the 2023 planner, the state argued the planner indicated in anticipation of fleeing the country that Ms. Adelson was selling personal items. Well, yeah. In addition to the signs on items about how they were to be sold. Sure. Admission of the complete planner would have corrected the misrepresentation made by the state, as there were 39 other entries in the planner where Ms. Adelson listed to sell the identical items as far back as January 2023. Okay, but you could have admitted that evidence through your client, but it's hearsay. You can't admit those statements yourself, and the state didn't admit them, and it's not completeness. Those are hearsay statements. If you wanted those statements in, you know how you get those statements in? All of you know. Chat, you know. Donna has to testify. You want that information in? Donna has to testify. You can't use her hearsay statements. Just what? And they know that. In Curtis versus State, the court recognized that judges have a duty to admit evidence that does not fit neatly within the confines of the evidence code in order to protect the defendant's right to a fair trial. It would have been error to admit it. As the court admitted portions of both planners, there is no question concerning the authenticity of the materials. Exclusions of the planners infringed on Ms. Adelson's right to present a defense. No, it didn't. Donna still could have testified. Donna Adelson testifies. Donna could have testified. You said the whole time Donna was going to testify. Donna testifies. You can't admit self-serving hearsay. The reason the state can bring it in is because it's offered against a party opponent. This is like day one of hearsay. Party opponent. They tried. I think they made a valiant effort to try to get this information in. But completeness didn't fit because they are separate entries. If Donna testified, it would have all come in. She didn't. That's a strategic decision that you have to make. You can't have it both ways. Like, between you can't have your cake and eat it too, and the cake is a lie, the analogy is somewhere in the middle. We're definitely having cake at the dinner party, though. I like cake. All of you are shocked by this information. Absolutely zero. All right. The court admitted portions of both planners. There's no question concerning the authenticity. Exclusion of the planners infringed on Adelson's right to present a defense. And the evidence was important to defeat the argument that she was fleeing to avoid prosecution. She could have done that. Thus, the court erred in excluding the planners as evidence. Notice how fast they moved on, right? KK in the chat said, question, why is it hearsay if the book was entered? The entire book wasn't entered into evidence. Portions of the planner were entered. The prosecution using Donna's writings against her is using a statement of an opposing party opponent. So opposing party who is the party opponent against her. The prosecution can use Donna's words against her. If you're thinking like you have the right to remain silent, anything you say can and will be used against you, the state can use Donna's words against her. The only way that Donna can use Donna's own words to defend herself is to get on the stand and say them. Otherwise, it's hearsay because it's her trying to admit her own written statements. So the entire books weren't entered. Only certain entries were entered. The books were marked for identification. Well, only one was marked for identification. The other one wasn't even marked for identification. One was marked for identification, but only certain portions of it were entered into evidence. So hopefully that helps make that clear. A lot of you are pointing out in the chat, just like in Karen Reed's case, the state could use clips of her interviews, but the defense couldn't enter in the rest of her interviews. Exactly same. Exactly same. So they're arguing the court erred in excluding the planners as evidence. I disagree. We'll see what the state has to say. I don't think that's error. We'll see. They argued this. It was denied. It'll be denied again, is what I suspect. For other cause not due to Miss Adelson's fault, she did not receive a fair and impartial trial. It goes without saying that all defendants are guaranteed a fair and impartial trial under the Florida and U.S. constitutions. Yep. Due process clause of the 14th Amendment, the right to an impartial jury. Yep. Were the jurors not impartial? They're going through the 14th Amendment incorporates the essence of the 6th Amendment right to be tried by a panel of impartial indifferent jurors whose verdict must be based upon the evidence developed at the trial. As Chief Justice Warren has observed, the constitutional guarantee of due process requires the courts to safeguard against the intrusion of factors into a trial process that tend to subvert its purpose. Okay. And specifically, the courts must vigilantly guard against the atmosphere in and around the courtroom becoming so hostile as to interfere with the trial process, even though all forms of trial conformed to the requirements of law. Well, what are they saying happened? Chat, that's a rhetorical question. I think we'll get there. They're going to have to tell us. The court explained in Shoots v. Ladders. No, Emily. Eats, shoots, and leaves. Also no. It is spelled S-H-O-O-T-E-S. Shoots versus Ladders. No, state. Shoots versus state. Which is where is the quote? Where is the site to that state? Where is the site to that case? Is it up here? Did I miss it? Now I'm just getting real picky. I'm sorry. I just defaulted to research attorney mode. My brain just flipped a switch. I don't see the case site. Oh, there it is at the bottom. 2008. The court explained in Shoots versus State that the presence of courtroom observers wearing uniforms, insignia, buttons, and other indicia of support for the accused, the prosecution, or the victim of the crime does not automatically constitute a denial of the accused's right to fair trial. They cited other cases. They go on to say, however, there are situations when the atmosphere in the courtroom might infringe on the defendant's right to a fair trial. Okay. When such a claim is raised, a case-by-case approach is required to allow the courts to consider the totality of the circumstances. A defendant claiming she was denied a fair trial must show either an actual or inherent prejudice, CEG, the Schutz case, actual prejudice, words. Sorry, chat. Actual prejudice requires some indication or articulation by a juror or jurors that they were conscious of some prejudicial effect. That's a hard standard because the jurors have to say it. Inherent prejudice, on the other hand, requires a showing by the defendant that there was an unacceptable risk of impermissible factors coming into play. Okay. This is a case where the cumulative effect of a number of factors constitute inherent prejudice resulting in Ms. Adelson not receiving a fair trial. Did the jurors say anything about this? We only saw the one interview. So I'm curious to see where this goes. So chat, if you've heard anyone cover this already, no spoilers. I'm going to keep asking rhetorical questions out loud because that's how I process what's coming up that I want to see answered. So I'm letting you know the questions I want to see them answer in the motion versus the chat being like, no, we already read this. They say this. Thank you for riding with the difference with me on this one because I'm curious as to where they're going with this. When the court would rule against the defendant on many occasions, the members of the gallery supporting the state would laugh out loud. Really? Counsel for the defendant brought this to the attention of the court. I mean, the court admonished the gallery numerous times. The defense brought stuff up that we heard on the record the last day. I wonder if this was brought up at sidebar before that, because the judge admonished the gallery almost every day before the start of trial. I'm curious to see if this came up at sidebar before, because we did see it on the record at the end of the case. Counsel for the defendant brought this to the attention of the court, and the court appropriately advised the gallery that this was not acceptable. It's not acceptable. I don't remember hearing any laughing. I remember hearing laughing that sounded like it came from maybe the gallery and the jury when the undercover officer was talking about not being very attractive and thinking that his face scared Donna. His statement that oh, well, I'm not very good looking, so I might have scared her. I remember laughing then. I remember laughing at a few other points of trial like that. I don't recall hearing anything that stood out because we would have rewound it and been like, what the fuck's happening in court? We want the tea. I don't remember things coming up that we heard on stream. It doesn't mean they didn't hear it in court, but that we heard on stream that was during rulings and things. Then again, I'm curious to see what they point out because the court did advise the gallery. The conduct continued throughout the trial and the court took no action to remove those who violated his order. This undermined the credibility of the defense in the eyes of the jurors. That's a leap. Are you sure it wasn't all of your own behavior? Because I think if some of the members of chat had been on the jury, referring to the victim as Danny in opening statements already turned chat off on the defense attorneys. Chat was already put off. Immediately ew, what? Why are you doing that? And then screaming at the jurors during closing might have also been off-putting to the jurors. Priya, this is a good point. Can we approach? No. And then there was laughter. That did happen once. That was actually pretty funny in the context of the entire day, though. That was kind of funny. I'd forgotten about that. That's a very good point. There's a lot of other things that could have undermined the credibility of the defense in the eyes of the jurors. Also, I think that the court a few times asked the bailiffs if they knew who it was and asked the defense if they knew who it was. There was also, let's see, I'm just trying to go by my memory before we get into the rest of what the defense says. The bailiffs seemed to me to be incredibly cognizant of what was going on in the courtroom. They also seemed like no bullshit. And when the defense witnesses were in court, the bailiffs were like, no, that person has been there for 15 minutes. Like the bailiffs had everything fucking clocked. So if somebody was acting up in court, I would expect that the bailiffs would have gone to the judge and said, this is not okay in our courtroom, because the bailiffs were really on top of what was going on in court. But they say the conduct continued throughout the trial, and the court took no action to remove those who violated the order. This undermined the credibility of the defense, they say, which I repeated. They go on to say not only were they laughing out loud, videos and images captured throughout the live video casting the live video casting? It's a net cast? Okay. Through the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. I didn't notice that. I'm not saying it didn't happen. I wasn't in the courtroom. But I didn't notice that on the stream particularly. But if gallery members were having large reactions, they should have been removed. It's inappropriate to do so. And it can influence the jury, which is why it's inappropriate. It's inappropriate if the gallery members sitting behind the lawyers are making like YouTuber faces, right? That's inappropriate. Or if they're just like, you know, if somebody's sitting in the gallery with like, you know, communicating how they felt about Donna, they would have gotten kicked out. But if somebody was also making large reactions, I would be hard pressed to believe that the bailiffs wouldn't remove them, and also that we wouldn't clock it. Because generally we would have clocked it. The only thing I really saw from chat a couple of times was chat asking if it looked like Harvey was asleep. That, and maybe, what else did I see asked? Who was wearing glasses? Who was sitting next to who? And if it looked like Harvey was asleep. That's really all I remember from asking about who was in the gallery. That's what I remember the most. Also, the judge was pretty dialed in. I don't think he would have, well, the defense is saying it happened. I'd be interested if they included screenshots or timestamps or which day or what, but you cannot try to influence the jury with big reactions in court. You can't sit there like when you can't be me in court, essentially. Emily, you should go watch these in court. God, it would be exhausting. Because when somebody's testifying and I'm sitting here going, please, that's inappropriate in court. That reaction is inappropriate for court. So I rather just sit here and watch it with y'all where we can be like, I don't think so. Counsel, what's that question? Come on now. We're not new. But they're arguing that gallery members were making faces and moving, like you put your right hand in, you put your right hand out, you put your right hand in. Sorry, they didn't specifically say the hokey pokey. They said that the gallery members were moving about to capture the attention of the jurors. Did any of the jurors mention this? I only watched the one interview. It would seem that if that was mentioned in the interviews, now is the time to insert that into your motion. It would make the argument stronger. They make the declarative statement This interfered with the juror's ability to focus. But there's nothing to back up that statement. It's just a blatant conclusion with no support. It's not even an argument. That's just conclusion. The court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. It wasn't that. It was that she needed to control herself. The law does not require that a defendant appear without any emotion. In fact, as in this case, appearing to be cold to the seriousness of the evidence in the case may cause the jury to believe the defendant had no care or concern for what the victim endured. She started boo-hooing the second that the medical examiner took the stand. The medical examiner was starting to say what their background, training, and experience was, and Donna was mushing her face all up. If Donna had been sitting there and like tears had escaped her face and she wasn't putting on, the court would have taken a break and given her Kleenex. But it wasn't even when the photos came up. It was before the photos. And then she was able to control her face, wasn't she? During the course of because the defendants also can't try to influence the jury with sympathy. During the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings. She did become tearful during the first sight of the autopsy photographs. I take issue with the word tearful. She started making faces when the ME started to testify about their background. It was before the photos ever came up. She was not sobbing out loud. She was not crying out loud. Oh, now we've gotten to this simple, short sentences, counsel. She did need tissues to wipe away her tears. Okay. But she made no noises that distracted the jury in any way. That would be distracting because you don't know if they were distracted or not. Even the victim's parents noted that she showed no remorse due to her lack of emotion during the trial. No, I didn't clock the victim's parents noting she showed no remorse during the trial. I think there's a totality of the situation there. The lack of remorse goes way further back than the emotion during trial, doesn't it? They go on to say this impacted the decision of the jury, resulting in Miss Adelson not receiving a fair trial. They've hodgepodged together a number of different arguments here. It's not very smooth or linear. I don't think Donna Adelson being admonished by the judge to mind her face denied her a fair trial. But I'm not seeing this argument the way the defense is. I'm just not. The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense case, the court demanded that, I was wondering if this was going to come up. The court demanded that Miss Adelson decide whether she would testify. They left out a little bit of this, didn't they? One of the key things they left out is that there was a 3-day weekend in between there. I'm sure the state will point it out. But the defense had requested, I think 3 to 4 days is what I recall, but they probably have the record because that's what I took notes on. But they did ask for more time than they used. On the second day of the defense's case, the court demanded that Miss Adelson decide whether she would testify. Both counsel for Miss Adelson as well as Miss Adelson herself repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial. All of these things could be done prior to trial. This conversation could have been had prior to trial. Why? Because nothing was new. But again, I do not have the perspective of a defense attorney. Perhaps I am unaware of the intricacies that sprang up during this trial that were unknown to the defense before this trial began. Things change. Trials are dynamic. Both counsel for Ms. Adelson as well as Ms. Adelson repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial. They didn't say it quite like that. In order to make a knowing and intelligent decision in what was probably the most important decision in her life. That is what they are like. That is what they are keying on. That her waiver of her right to testify was not a knowing and voluntary waiver. I think that argument might be something that they explore more when they get to the appeal stage of this. I don't think the court is inclined to change their mind on their own ruling. The appellate court might see it differently than the trial court. I don't see the trial court changing their mind. I see him saying, you had a 3-day weekend. The evidence that came in is consistent with the evidence of the first trial and the second trial, or in Charlie's trial, this trial. So you knew what evidence was coming in. You interviewed all the witnesses that the state was bringing. There was no, quote, new evidence, and the trial had already been continued twice. So Donna knew what was coming in at trial. And you had a whole 3-day weekend before, and the court broke early the day before. But an appellate court might say, you know what? She needed more time. And if the appellate court decides that she needed more time, it will go to retrial. And if it goes to retrial, do you think she would testify? I still think she wouldn't. Maybe she would. I don't think her testimony would have changed things. I think the way the state got into Charlie's like double extortion plot threw all of this off. And I think that's what they needed to really address together. And I think they probably needed to evaluate what the jury thought of the jailhouse informants. I think those are the two big things. But we'll see. But that's what they're going to argue on, I think, at appeal to, that this was not a knowing and voluntary waiver on Donna's part because she didn't have enough time. I think it was the right decision, though. I really do. They go on to say that this was especially significant and that the state made numerous changes to the evidence during the trial. I'm curious to hear more about that. I hope that's what they tell us next. When the court recessed early on September 2nd to allow counsel to meet with Ms. Adelson, we first spent a great deal of time reviewing the exhibits actually admitted so that we could discuss them with Ms. Adelson. Right, but you could have talked about a lot of them before. Counsel then drove to the detention center to meet with Ms. Adelson for the 2 hours authorized, arriving at approximately 5 p.m. Counsel did not have enough time to go through every exhibit with Ms. Adelson during this meeting. Counsel advised the court of this fact the following day when the court inquired about Ms. Adelson's decision. If the jail didn't give them enough time, couldn't they have asked for more time from the jail? It seems like they would have been able to ask the court to get an extension on that, right? Maybe not. I mean, it seems, I don't know. It seems like there are ways that they could have worked with this. Amber in the chat said court got out early this day. Yeah. And they did mention that. They did say at the beginning of the paragraph that court recessed early September 2nd to allow counsel time to meet with her. But they're saying it still wasn't enough. They go on to say, not only did the court force the defendant to make an uninformed decision, he threatened to hold counsel for the defendant in contempt of court because they were continuing to speak to their client about this important decision that she had to make. Well, counsel, now you're just rewriting history, aren't you? Aren't you? Because that's not why the court said, do we need to talk about contempt? It's because they kept refusing to answer him. I seem to recall that Judge Everett was asking the defense questions and they weren't answering him. And he said, I'm not, and I'm paraphrasing, I'm not talking just to talk, counsel. The defense was just ignoring him. It was not, okay, that is out of context. Not only did the court force the defendant to make an uninformed decision, that's going to be their lead argument for the appeal. He threatened to hold counsel for defendant in contempt of court because they were continuing to speak with their client about this important decision that she had to make, which again brought an audible derogatory response from the gallery. The jury wasn't in at that point. What did the gallery say? All of you are saying, no, that's the exact quote. Okay, good. The court specifically said, because I think I said, oh shit, and rewound it. I'm not just talking to talk. Because they kept ignoring him. He was holding them in contempt for not answering him, not for not saying that she was going to testify or not. That's how I took it. I want to know what the auditory derogatory response was from the gallery. Has anyone said? Because I imagine it was similar to our response here. And when the court said, do we need to talk about contempt? I went, oh shit. Court's pissed that they won't answer. Why isn't anybody ready? Like, that's what we did over here.
Why is no one ready?
That was our response. Did somebody in the gallery say it? Oddly enough, whenever the state needed additional time to set up electronics for opening statement, for witness testimony, for closing arguments, and even additional time to make their closing argument, the court not only gave them the additional time, he joked with the prosecutors about it. Counsel. Every time the defense needed anything, the court sat and waited. Sometimes he did have the angry typing happening. Occasionally, you got the angry clicky, clicky, clack, clack. The only time he didn't give them more time was when they said, may we approach? And he said no. And then they said, but Your Honor, blah, 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 blah. And he goes, fine, approach. He gave them so much time. Okay. He gave the state time too. But he gave the defense time too. Every time the defense was like, we need a few minutes for cross, the court said, okay. I'm sure they felt like they didn't have next time or enough time. They felt rushed through this whole thing. It was as if the trial caught the defense team by surprise. But that's not the judge's fault. This trial date had been set for quite a while, and he gave them an extension. He continued the trial. It was supposed to go forward in May, and he continued it. I'm glad he did, because it would have gone forward at the exact same time as the Karen Reed case, and that would have been a mess. So I'm real glad it got continued, but it was supposed to go forward in May. What were they doing during that extra time? Because it doesn't seem like they were preparing for trial. And I get that it's hard to prepare for multiple trials. It is hard. But it's also the job. It goes on to say that the court joked with the prosecutors about it, thus leaving the clear impression that he favored the state in this case. I mean, I think he would have joked with the defense too if they had been joking with him, because we definitely saw Georgia Kappelman joking with the court a little bit and the court joking back. I would imagine they know each other better, but I don't doubt that to the defense, it felt like he favored the state. There were definitely times the defense seemed to annoy the court. However, I didn't see anywhere where I thought the court held that against them. What I saw was, wow, he's annoyed and he's still giving them what they're asking for. I don't think I could do that. And all of my comments on it was, I don't think I'm as patient as this judge. Because I would have been so mad. The defense goes on saying, surely the decision of a defendant facing life in prison is more important than the extra time the state requests to conclude its closing argument. I mean, okay, sure. The defendant's request was not granted and made a huge impact on the outcome of the case. I disagree with the last part, but he kept giving the defense more time. And that's how I see it. They go on to say the court showed favoritism to the state at most every juncture of the trial. While the trial had delayed starting times to accommodate the state's needs, there was a whole day they started like 45 minutes late because of the defense. When did they start late because of the state? There was once that the state had a tech issue that I can remember. Whatever. While the trial had delayed starting times to accommodate the state's need, the defense was required to meet its tasks over the lunch breaks, thus not allowing counsel time to adequately meet the obligations of counsel for the trial, resulting in the inability to consume lunch over the break. Counsel, were you watching my feed? Counsel, were you watching my feed? When I said, what the fuck are they doing over lunch? Why aren't they ready? Were they actually eating lunch? Because I said that one day and all of you were like, Emily, what are you talking about? And then we talked lots about lawyers and lunch breaks. But there was a day where I was like, what the fuck did they do over the lunch break? How is no one ready? Your Honor, we didn't even get to eat lunch over the lunch break. And while I think we should normalize work days that don't require you to not eat because you actually do need to when you're in trial, it's also like a huge part of the thing. And I think Attorney Alessi nailed it. He just brought his lunch with him. And I'm sure he was doing work with one hand and eating a sandwich with the other, as happens quite a lot. They go on to say the court sustained the objections of the state without giving the defense an opportunity to respond. Under some situations, sidebar arguments were made, but on more than one occasion, the court denied the defense's request to approach. I thought it was only one, maybe it was more. Additionally, even when the court sustained a defense objection at sidebar, when the sidebar was concluded, the court announced to the jury that the objection was overruled. I don't trust the defense as a historian in this. I would want to see the transcripts. During one sidebar discussion, the court asked counsel a question. As counsel attempted to answer the question, counsel was met with a scolding to not talk over the court. Well, then the court wasn't done asking the question, were they? Counsel thereafter was prevented from answering the court's questions. Give me the transcript. I don't believe you. I just don't believe you. I want to see the transcript. I need context. I need context. The court said not to talk over the court. Right. You guys did that a lot in open court. I imagine you did it in sidebar too. And every time the court cut the defense off and said, who's arguing this? Because they kept trying to go, two riders, one horse. The court would say, who's arguing this? And keep them on task. I never saw the court cutting off the defense in a way that was inappropriate. Not that we haven't seen it in other courts, but in this court, most of my memory of the court was about the court's patience. Oh, they're going to make this worse. The temperament of the court towards the defense counsel was regarded as negative and gave the appearance of partiality for the state on the part of the court to not only the defense, but spectators in the gallery, the media, and those viewing the trial through the media. Most of that counsel was when the jury was out of the room. The impression left to us was not when the jury was in the room. Your Honor, everyone thinks you were being mean to us. I don't think the judge was being mean to you, counsel. I think the judge was being too patient. I was rooting for him to be meaner, honestly. I was like, come on, Your Honor. Don't give him another 5 minutes. That's not how counsel sees it, clearly. They go on to say that fellow defense attorneys commented that they had appeared before the court in trial on similar charges, and they were shocked to see the obvious disdain the court showed towards Miss Adelson and her counsel in this case. Show me the texts. Also, Your Honor, other defense attorneys said that you were mean to us. Excuse me, Your Honor. Tiffany called and said that she thought you were mean to us. So we should get a new trial. Because, like, other people saw it too. We don't have any legal arguments that are happening at all right now. They're trying to get to, I think, judicial bias. But, Your Honor, the media thought you were mean to us. I didn't see any of that. Somebody point me to where anybody said that the court was too harsh on the defense. Because when the internet feels like the court's being too harsh on the defense, it's everywhere. All I saw were comments about how patient the court was. Your Honor, fellow defense attorneys commented that you were so mean to us that they were just shocked at the disdain. Counsel, did anyone comment to you that they were shocked about how unprepared y'all seemed the entire fucking time or nah? Where are we at on that? Because it was painful. All of you are saying the defense attorneys are probably the Wendy's attorneys that appeared. You're probably right. Wendy's divorce attorneys. Although there is a standard jury instruction to the jury that they are to disregard anything the court may have done that led them to believe he favored one outcome over another, and that was read in this case, it is not realistic that the jury can set those feelings aside. The jury clearly disregarded the instructions of the court on other issues and did so on this instruction as well. Said fucking who? Nobody from the jury said that. Most of the times that the judge seemed frustrated with the defense was outside the presence of the jury. That's so conclusory. There is no backing on any of this. It's just like statement after statement after statement. Like, but Your Honor, you just weren't fair to us. I mean, I guess that's consistent with counsel. This is the way that they made their closing argument, right? When you can't argue the facts, just bang on the table. We're just banging on the table at this point. But Your Honor, you didn't like us. Me. This is not a persuasive argument to me. Do you think the judge is just like, okay, counsel? I can't wait to see what the prosecution says. Will they even address it? Maybe not. Maybe they will. I hope the prosecution takes a moment to be like, every time the defense asked for more time, the court gave them more time. Maybe not as much time as the defense wanted, but the court gave them more time. So all of you are saying we need some cheese with that wine, and now I want cheese for lunch. I mean, I guess early dinner before I go to football. But I am now desperately needing cheese. I have been influenced by chat. I need cheese and maybe wine. Well, champs, sparkling, at least. The judge clearly disregarded the instructions, or the jury clearly disregarded the instructions of the court on other issues. Those issues have not been highlighted here. What jury instructions did the jury disregard? And they did so on this instruction as well. Doubtful. The totality of the circumstances present during Miss Adelson's trial establish inherent prejudice to which there was an unacceptable risk of impermissible factors coming into play. Wherefore, defendant respectfully requests that this honorable court grant this motion and grant Miss Adelson a new trial and for such further relief as is just and proper. Respectfully submitted by Zellman and Fulford. This is just my speculation. I'm just speculating that this was written by Fulford. This does not sound like Zellman in the writing of this. It sounds like Fulford. I'm going to take a look at the docket real quick and see if there's any updates today. Because this morning I did not have a chance to look at the docket fresh. I pulled things last night to make sure that we had all of the documents that were up to date. But let me go look real quick and see if there is any update from the docket today, because now we're at the end of the court day in Florida. Well, maybe not. Florida is just like, we're working full days, like full. Like not these pretend fake little California days. We're working like real days. I'm not prepared for court to be like, we'll just roll to like 6:30. It's fine. Let's see. No, all I see is the defendant's motion. And the defendant's renewed motion for judgment of acquittal was also filed, but there's no docket image. So when there is a docket image on that, I'll grab it. But there is a renewed motion for judgment of acquittal. I imagine it's just same, but it's not uploaded onto the docket yet. So if that does get uploaded onto the docket, we'll cover it. I'm just waiting for the prosecution, who I imagine has 10 or 15 days to cover this. So when the prosecution replies, I will cover it. I'm going to do a quick summary of this, and then we're going to get to Q&A, and then I need to get to, it's Friday night, it's football time. But when the prosecution responds, we'll get there. At the end of the 18-page motion of the defense asking the judge to allow them to interview jurors and for a new trial, I think their arguments on the facts and the jury instruction in the law is probably one of their strongest arguments for the motion for new trial. The motion that they're going to make on appeal and that they've made here with regard to the defendant not having enough time to make her decision to testify or not is, I imagine, going to be one of their primary arguments on appeal as well. It's unlikely to me that the trial court, given the totality of the circumstances, is going to change their mind. I imagine Judge Everett is going to say, we had a 3-day weekend. We broke early. This trial had been continued. The motions or the evidence that came in at trial was similar to the evidence at the previous trials. You had advance notice of all of it. So you knew all of this, and you were still asking for more time, and more time was not needed to make the decision. You knew when we broke for the 3-day weekend that this decision was imminent. So I'll be interested to see what the Court of Appeals thinks of that argument, because I don't think Judge Everett is going to be persuaded by it. I think his words were to the effect of, you knew this time was going to come. You knew this decision was going to have to be made. The time is now to let us know what you are going to do. You knew. What's interesting to me is they're asking to interview the jurors. They didn't line out the standard that would allow the court to interview the jurors. They just put in the legal standard of, if the jurors disclose that there was any impropriety when they are interviewed, then what happens next. But they didn't include any standard about when jurors are interviewed or how the court evaluates jurors being interviewed. I imagine we'll see that in the state's response. They were arguing that the jurors should be questioned about the foreperson posted on TikTok saying that they had been selected for a jury and that they should be questioned about that. You're allowed to say you've been selected for a jury. You're allowed to say you're a juror now. You're allowed to say that you are, going to be on jury duty and might be unavailable. You can't talk about the case. And nothing the defense argued says that the jurors talked about the case before the verdict was rendered, before they deliberated. And then they argued that the other juror who gave an interview said that they looked at how Donna was responding to things, but didn't consider it. but that it's improper to consider it. So they might have considered it, but we need to ask them that they might have considered it. Okay. I don't know what standard the court will use to determine if there will be juror interviews. I'm not persuaded that they need juror interviews at this point. But could I see the court saying abundance of caution, let's bring in the juror and being like, hey, did you talk about this case before you deliberated? No? Okay, done. We'll see. I want to know what the standard is. Hopefully the state will line it out. So strongest arguments, I think, for the defense, though I don't think they'll be persuasive on a motion for new trial, are going to be Donna needed more time to decide to testify, and the defense will keep arguing there wasn't a knowing involuntary waiver, and therefore she did not adequately waive her rights. And two, that the totality of the evidence does not indicate that Donna knew or took action before the murder for the solicitation charge and the principal charge. It's a technical legal argument that might not go very far with jurors, but might go somewhere with a court of appeals. Might not. I'm interested to see how the court lines out their totality of the circumstances. So with all of that, the state's going to respond with their opposition. We'll get a reply from the defense, and then we'll get this set as a hearing at some point on a hearing for motion of new trial. I don't know if the court will set this before the next court date in October because they have a status conference set for October. Maybe they will, maybe they won't, but I will tell you in the Lawnerd app when the next court date is so we can watch it together because I very much want to know. I'm very curious. So on that, we will keep an eye. And chat, all of you are like, are we going to go look at the TikTok? Yeah, let's go research together. We're almost to Q&A. Let's go see if we can figure it out, right? Let's see. Give me just a moment to try to pull up. I had this saved in other notes, but not in my notes for today. So it's just going to take me a moment to go find where my other notes are so I can get to that account more easily and then fight with the clock app in other ways. But Crystal, thank you for pointing it out. Others did as well. You guys were like, wait, I thought we'll go do it now. We'll go do it now. I just need to find it because I had it from stream prep from last month. So let me just pull it up. We switched months. So I think I pulled up that individual's TikTok. I just need to find where I put it. So give me a sec, chat. Apologies. It's here somewhere. This is why I keep all of my my live stream prep so that I can find what I need to. I don't think I put it in trial. Maybe I did. No, maybe not. Now I thought I put it somewhere. It looks like it is. It should be right here. And I do not see it. Maybe it's down a little further. Hold on, chat. Thank you. And apologies. I'm going to start saying, what's the worst thing I could say? Well, that we have to wait for just a minute while I try to find where I put this. I'm not seeing it in my prep, which is really strange. Oh, because I was looking at the wrong month. Okay, that was totally on me. Okay. Found it. Let's see. You guys know how I feel about the bird app. I'm going to try to see if I can find the date. Chat, remind me what date. What date did they say? Like August 25th, right? Let's go see if I can find this by date. We're just going to do it together. All right. For all of the annoyances of me trying to find something on TikTok, I apologize in advance. I am sorry. It's going to just be what it is. Let's try to do it either way. Wait, that's too much. No, that's too much. Okay, this was the hey, I can talk. Freaking TikTok. That was the yes, I can talk about it now. That looks like it was from September 5th. So, oh gosh, if we just go down, I'm going to mute this. If we just go down, should the dates change? Okay, good. This is not working. The UI on this is freaking killing me. What is this app even doing right now? Like, what is this? I don't even know. Chat. I don't know. So this looks like the 3rd. That's the 3rd. This is August. Let's see. This is August 31st. This is August 26th. This is August 26th. This is August 25th. This is August 25th. This is August 24th. Okay. So wait, does TikTok have like slider posts? Is that what we were seeing? I am. I'm just like, what? All right. We're going to go take a look at, let's see, the 25th. Okay. So the TikTok has, I'm just going to describe it and then put the volume on. The TikTok has graffiti that actually looks like an intentional graffiti style billboard or whatever. And it says, you aren't the main character. It says rude. And it's got the that was rude meme. I mean, I agree with this.
Fucking rude.
Agreed. Like, agreed.
That was rude.
Yeah.
That was pretty fucking rude.
Agreed. That's rude. It is rude. We're all the main character. Super rude. All right, next one.
I'm not a poet.
This says, I'm just a woman. This is from August 25th. Somebody's asking ChatGPT for workouts.
Just a woman.
Okay. This is a slider post. All right. This is about hip workouts. Great.
I have to get back to work.
This is from August 26th saying, apparently I have to get back to work.
This is bullshit. Anyway, apparently
I mean, I don't disagree with this either.
I have to get back to work. This is bullshit.
I mean, not wrong. Not wrong. This looks to be taken in the same location, same outfit, same day. I'm resonating very much with this.
Get back to work.
Valid.
This is bullshit.
Also, her glasses are so cute. All right. The next one is this one. I'm gonna get the left. Why is the music so overclocked in one and not in the other? Why is there no consistency in the volume of the fucking sound? Okay, it's 8:26. No work, no kids for most of the day. You know what? Heaven. Everyone who would want to be on a trial, right? So this says, when I told God I needed a break and he makes it so I'm selected to serve on a jury for a 2-week trial. And she says right here at the top, I can't scoot it over because it will disappear. But the comment to that is, no work, no kids for most of the day. You know what? Heaven. I mean, okay. So that's it. Hey, I was tired and I got selected for a jury, which means I don't have to go to work. I'm not at home. And I get to just sit here and be in a spot. I get to just sit here and have snackies. I mean, that's not a problem. Also, girl, you're not wrong. There's a song for this. That's so loud. Okay. So she got selected. When I told God I needed a break and he makes it so I'm selected to serve on a jury for a 2-week trial. Okay. That's a break. Fair. Don't have to go to work. But you're also not at home. But you're also out of the house. You get to have lunch by yourself. Sure. I don't know if there's another video, but she's a mom of young kids. Like, you get to eat lunch by yourself without your coworkers asking you questions, without checking your emails, and without also taking care of your kids? Sure. Fair enough. So if that's the only one, and again, the other statement on that, as I said, no work, no kids for most of the day. You know what? Heaven. Hashtag, won't he do it? Hashtag jury duty. That's that same day. Let's see if there's anything else from this day. The next day is from August 31st. And yeah, this is from August 31st.
I don't know. Also, I don't know.
The tags on that are hashtag relatable, hashtag ADHD and women, hashtag mom life be like. And the comment section from September 5th said, which witness made you make this video? From September 1st said, when you're speaking publicly and become increasingly aware of how you sound publicly speaking and lose the train of thought. Somebody else said, I was going to put a comment, but then I forgot what it was. So a lot of people were just commenting on, yeah, me too. Same. Oh my God, the volume is so loud on these. This is September 3rd. It says, felt cute, might delete later. IDK. Hashtag another day, another sleigh. Okay, but she looks cute. I mean, fair. It says hashtag felt cute, might delete later. Is the misconduct that her hair looks so good early in the morning or no? Where are we at? Like, it's kind of rude that she looks really good in orange and blue. Maybe. Is that what they're mad about? Chat, you're going to have to help me out. Is it that the lippy's too good? Is Jackie jealous of the hair? The hair is cute. All right, that was September 3rd. This is also September 3rd. No, yes, September 3rd. It says, drab to bad, having two kids has made me 100x hotter. Hashtag another day, another sleigh. And then a photo reel of photos of her from 2020 to 2025. I mean, ma'am, get it. Oh, a good photo. The makeup is makeuping. The light is great. The hair's popping. Again, facts. Laura M in the chat said she's serving jury duty and looks. 100%. Okay. So that's September 5th. And now we get to verdict day. And she's posting about those. And we already saw those. So I don't know if there's any more than this post where she says, I'm selected to serve on a jury for 2 weeks. If there was something else, I guess that they will post it. But if this is it, this is not talking about the case. You are allowed to say you're on jury duty. This is not talking about the case. So I don't know if she deleted anything or not. I don't know if this is the one the defense is referencing or not, but it's on the same topic. Also, you're allowed to say that. So if there's something else, I guess we'll see. If this is it, the judge is going to be like, are you kidding me? Like, the hashtag is jury duty. That's not talking about the case. If there is more than this, I'm curious. Let's see what I'm going to look real quick to see exactly what the defense said, because that TikTok is from August 26th. We got to go all the way back to the top. So give me 1 second. Let me get to the top of this motion real fast and see what they say about the juror misconduct, just so we can juxtapose it, and then we'll get to questions. Let's see. Where did they talk about TikTok? Did I already zoom past it? No, juror interviews. Did juror interviews come next? Sorry, chat, that you have to scroll with me while we scroll back to the juror misconduct. Hold on. Let's see if this will OCR. Nope. No. We can't find it. Maybe? Oh, wait, maybe. Maybe. All right. No. It's not OCR'd. All right. I cannot search because it will not search. But let's see. That's the jury. It was it was right at the beginning. I agree with you, Chad. I think we have gone too far. I scrolled too quickly. Let's see. No, there it is. It was like literally page 2. Sorry, chat. Subsequently, at the trial, juror number 7 went viral on TikTok. We contest the virality. Concerning her jury service, she revealed that she posted on TikTok during the trial. In reviewing the TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26th. A flash drive with the video will be provided to the court, as the undersigned has been informed. So the lawyer doesn't know. The lawyer is saying someone told me it's been deleted. The undersigned has been informed that particular TikTok was deleted from her account. Okay, well, the TikTok we looked at from the 26th, this is from the 26th, said that she was selected to serve on jury duty. Is there another one? Because she posted this on the 26th too, and it said, the adulting is hard. It looks like this is recorded in the same location. And then this was posted on the 25th. So, I mean, this is, you know, okay. This is posted the 26th. If there's another one that's been deleted, then there's another one that's been deleted. If that was it, then, if that's the TikTok, if the TikTok is her sitting out there saying, I needed a break and now I have 2 weeks that I don't have to go to work, but I'm at jury duty and I get to just sit here and do the thing, that's great. But the defense attorneys don't know if it's been deleted, because what the defense said was the undersigned has been informed that particular TikTok was deleted. So I don't know if there was a deleted one or not, but the lawyers don't know either, because the lawyers are saying that somebody told them. Somebody told me. Never. No, Emily, no. So. That TikTok seems consistent with what they're saying it says. And they provided it to the court. So if that's the right one, they provided it to the court. The undersigned identified she posted a TikTok that she was selected as a juror. Okay. But if that's it, I don't think there's much more to do with that. Insert funny name. Thank you. That you had a boyfriend. Thank you, chat, for singing along with me. I am not I am not persuaded that they are going to find the misconduct that they are looking for. Well, Your Honor, we put it on a flash drive. Look, it's best practices for lawyers to save things that they see on the internet. And then if they need to, send a subpoena or a preservation notice. It is best practice to, at minimum, get a screen recording. If you can get a download, get a download. It has to be preserved, but you can also send a preservation notice. But like, I've been informed that it was deleted isn't going to be helpful. So we'll see, I guess. I'm interested to see what the prosecution has to say. The prosecution might just say, jurors are allowed to say they were selected for jury duty. Nothing the defense argued shows that the juror discussed the case. They didn't even allege the juror discussed the case. They said that the juror said they were selected for jury duty, which they're allowed to do. They didn't even say it was this case. So I'm not persuaded. I'm not persuaded. Let's see. Somebody in the chat said, yeah, or said which case. It 100% Priya did not say which case. Lucia said, can they make TikTok show them what was deleted? They can. They can send a preservation notice. For sure. Trisha said, I wish I had the reach distance the defense is exhibiting here. I mean, it's nice to suspend reality sometimes, right? Katya, generally, no, you shouldn't talk about the case that you're on, and that would extend to, oh, I was selected for this Adelson case. You might have heard of it. I think that would be very on the line. Saying I was selected for jury duty is fine. MB said Mr. Fantastic level of reaching. For sure. For sure. All right. Let's get to questions before I have to bounce to football. Because I'm getting close. We are going to be getting close to football time. Heliotropic in the chat just said, go, go, gadget arms. Facts. Absolute facts. And in going of order of oldest to or newest to oldest, Danielle will allow the off topic because some of you have been around since the days where I was simply talking about tech. It was so much fun to meet some of the tech YouTubers at Made on YouTube who I had watched for a very long time. I was just like, I love tech YouTube. I love tech YouTube videos. I love tech YouTube. But off topic, but iPhone day, which iPhone color did you get? I haven't even opened it yet. I haven't even opened my phone yet. Blue. I went with blue. But you know what was wild? It was wild being in New York with YouTube this week and watching creators first like raw dog their phone with no case, and second, filming with the orange. And I was sitting at Made on YouTube, and there are just orange iPhones sitting around on like Tuesday. And I was like, how do they have them? It was kind of fun to see them in the wild, but no one had a case on them. Everyone who had the orange iPhone was just like sitting out and being all orange and shit. And I'm like, oh, new iPhones. Meet me at the sidebar. Do they give you all the phones? Oh no, I woke up in the morning and ordered this with my hot little hands. I do not get review units. I do not get tech units. I do not get invited to the things. No, I am not in the tech space at all. So no. I have talked to Apple on occasions about stuff related to creating streaming content, but no, I don't get review units. So it was fun to see people with their new orange phones. I'll tell you if I think it's worth it for most people. Generally, most iPhone updates, I'm like, you're probably fine. But I cannot wrap my brain around, I don't want the new camera. And cameras generally drive the decision for me. Also, I am so locked into the Apple universe that switching to other phones is difficult. And I'm still not at, I want to carry around a camera, like a physical camera. But at Made On, Sarah Dici, who is a tech YouTuber, was carrying her camera with her. And I'm like, you know what? I'm kind of living for the let's just grab a camera and take pictures again. Like, I'm kind of here for it. Alto said, is the orange pretty in person? It is orange. So if you are a big fan of orange, it is very orange. It is very like utility, camping, hunting, orange, very orange. It's very orange. It's, yeah, not orange for me. But it is orange. So that's what color I went with. To all of the new members, thank you. To everyone who gifted memberships, thank you. So Maya asked, will I cover David's case with the deceased victim found in the Tesla? I have been asked about this case so much. Like, I have been asked about this case so much. It is the number one thing. I don't know about the emails. I will have to ask Team Baker, but it is the number one thing in my DMs. And other than people saying, can we talk about Donna? The exact next thing was, can we talk about David? That was the exact next thing. I will take a look. There have not been charges on this case yet. That might change quickly, but I'm going to take a look at what is known from official sources. If I do not cover, if there is, I will see what I can cover from official sources before charges, depending on what we have. But it is definitely on my mind. The victim is a young teen, which is tough. So I am going to look into it more. I will let you know. It is not an immediate no. We'll see. But I want to see what information we have from official sources before we jump in, because we are still pre-charging and pre-arrest. I do not know yet. So we will see. Ellie said this motion says more about Donna than she thinks. It sure is. Erica said, I want to be a fly on the wall when Georgia reads this. Georgia's going to read this and be like, no, 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 no. That's what's going to happen. The virtual juror said, off topic, Karen Reed Civil is going to have media access. I'm glad to hear it. It should. We have stuff to catch up on this case, like a bunch. We do. Frankie's mom says storing the dishes was funny by the detective. Oh, I think there were laughs for that too. There were some chuckles. Like, I mean, we store like the holiday dishes in the closet. There were some chuckles for that, but that's appropriate. Music to My Soul said, when Lawyer No interviewed juror number 6, I asked if the jury loved Judge Everett as much as we did, and the juror said that the jury adored him. I love that you got to ask the question, Music to My Soul, and I'm not surprised by that. I think the jury probably loved him all of the time. And no, it's not wrong that it validates your decision that I chose the same model. I mean, I'll open the blue if you guys want to see it. I'm happy to open it now while I'm answering questions. They've made it so easy. You just like, there's just like a tab. I realize I should probably not with the rest, but there's just like a tab. So, let's see. Miss B. It's such a good level of shade. The defense is mad that the jurors' sleeves fit. Right? Like, right? Brandy Rose, thank you. I did. Dr. B opened it. It came. We have it. I appreciate it. The dragon mug that broke in a weird way has been replaced. So thank you. I appreciate it. Look. All right. That's the only thing we have to do to unbox these days. There's not even much going on. So Pam said there's a purple iPhone 2. I know. I am a pro model girly, And so I am always a pro model girly. But thank you, Brandy Rose. I did. I appreciate that. Music to my soul. Emily, I know you had to do the YouTube-y things and such, but we missed you. I missed you too. But I had a lovely conversation with Neil about YouTube. I got to talk to lots of the folks that work at YouTube that I know, and those are always great conversations. We will talk on a members only about the conversation I had with CNN about podcasting and news and media, because I was at a podcasting event for media that was mostly media. And by media, I mean like ESPN and CNN and all of the other networks, NPR, et cetera. And we had some really interesting conversations that are well off topic for now, but it was great comments. And then we were able to toggle off the leaderboard, and I got to see those at YouTube talking about how they see the platform growing. I've never seen a company choose to have creators be part of their product announcement. They had Mark Rober and some of the cast of Smosh and others on stage helping talk through the product announcements. And it was really cool to see, because YouTube as a company, if a YouTuber does something sketch, like you immediately see the headlines, right? YouTuber, insert name, insert thing. They always try to tie creators that have wilded out back to the platform. The fact that YouTube as a platform continues to lean into creators, even though sometimes that goes badly. Logan Paul really speaks to YouTube putting creators first, I think, and having creators on stage talking about the products that they're developing and working with the creators in development of products. We get asked about things that we can't talk about tools and things we would like to see on the platform that would make it easier for us to do what we do with you. And I love that they take our feedback. It's not just engineers going, but you need to do this. So it's very cool. Trisha Lynn said they also did a collab with Colin and Samir. They did, and they did one with John Yoshii as well. And John talked to Neil about that. I don't know. I didn't see Colin and Samir's video yet. I don't know if they also talked to Neil. Top Sale Girl said, why hasn't Corey gone to trial yet? Because her trial is set for February. We have a whole playlist. I did some videos on how it ended up getting bumped. So Christine D said, was this not covered at the probable cause conference? With regard to Donna Adelson, the motion that the defense is making now is that the evidence from the prosecution and the defense doesn't meet beyond a reasonable doubt. Probable cause is just probable cause. And then when you get to the end of the prosecution's case, the end of the state case, that evaluation is similar. Is there sufficient evidence? Now they are saying to the court, you need to evaluate the defense evidence and the state evidence together and then find if the totality is enough. So Beats Kill Bean said, so Fulford definitely wrote this. It reads like her to me. It absolutely does. Mama Bet said, are they saying pay later equals not guilty? I don't think so. I think the defense is saying, Your Honor, we've got to give it another go. Lita asked who responds to this. The state will respond. They will either have like 10 or 15 days. Trig said, Emily, can you read the comments you bring up on screen? They're hard to read. Love the purple lightsaber color though. We are working on making the font a little bit larger on our end. So particularly on mobile, it will show up better. So for those of you that asked about the phone, I'm going to try not to drop it, but this is the phone. In the chat, B asked, how long is Donna's sentence? She hasn't been sentenced yet. They will be back in court in October. So that's the phone. The two-tone color is different. I saw it in the pictures. I don't hate it in person. It's just different. It's very different. And the edges are very round. It's heavy. It's heavy. This is not a lightweight phone. This is the Pro Max. She heavy. Like this is a heavy phone. Do you know what's going to happen to this phone immediately? Pop socket. Immediately pop socket. Immediately pop socket. Oh, they moved the MagSafe up a little bit. Look at that. The MagSafe is up a little higher. Huh. Things that nobody asked about, but the MagSafe is heavy. All right. I like this phone though. It's pretty. I mean, the bump out on the camera is so aggressive. They're like, we Samsung now, but I love the pop sockets. That one's just a little higher up to me than this one is. Emily, it doesn't matter. You're going to put a case on it. I so am, but I like the look of this phone. This is heavier. I'm interested in the battery life. I'm interested in the new camera. This phone's prettier. Not sorry. So if you like your 16, I would keep it, honestly. I would just keep your 16. The 16's great. And the 16's great. The cameras are good. I'll let you know if the camera's that significantly better on another stream. But the 16 Pro Max versus the 17 Pro Max, this is heavier. I don't know if it's bigger. I think the screen size is bigger, but I don't think the actual phone's bigger. It might be a touch bigger. But there we go. Tech with EDB. I like the golds. I really do. But what I would do if you have a 16 and you're not sure yet, A, you don't need to rush to buy this. It's a fucking expensive phone and it's heavy. B, the rounded corners feel a little bit, it feels chonkier. Like I like them big and something. It's a little chonkier on the sides. It's pretty though, but I like the 16. I would try the new iOS and see if it feels like a new phone to you. That's what I would do. So some of you are like, just use an Android. I mean, I get it. If you're upgrading from older than like a 15, the camera on these is going to just knock your socks off. If you are upgrading from a 16, I don't know if the camera's going to knock your socks off. I'll let you know. I'll keep you posted. These aren't going to sell out so that you can never get them. You might have to wait 3 weeks, but these phones aren't going to sell out. So there will be the initial rush, but it might be that the orange takes a little longer to get if you're interested in the orange, but I will try the camera and let you know. I love the gold of this phone. I really do. So we'll see. I'm going to have to, it's heavier though. Net Detective said the 16 is heavy. The 17 is heavier. Yeah, the 17 Pro is heavier. You would need to look online. It feels heavier in the hand. However, I'm going to put it in a case. So either way, it's going to end up with a little bit of the case weight because I can't hold a phone this big without grip because I'll drop it. I just don't trust myself not to drop it. So this is the case I've been rocking on my 16. I like the square case. It's fun. So that's the case I've been using. I will add it on my Amazon shop if you guys are interested. That is a case from Amazon that I enjoy. But the 17 feels a little heavier. I'll keep you posted. I will let you know next week. I'm going to take a lot of pictures at the football game tonight if I can get this up and running. So it's a substantial phone. There's no doubt about it. But I like it. So Rosie Byrne said, just tuned in. Are we Apple sponsored? No, they just effectively take my money every year. And the Lawnards know that it's phone day, so we're going to talk about it. But I'll let you know what I think of the camera and how I feel about the battery life. I'll keep you posted. So I'll save you some money if I can. We'll see. All right. Let's see what else. Jojo, this is a great point. Jojo said, EDB, nobody mentioned that when you get your visa, they ask you when and where you will be staying. Also, the airlines you'll take. We didn't hear about where they'll be staying, but yes, we definitely knew they had a ticket. But we didn't hear about where they'll be staying. Pokemon, thank you for the super chat. Noelle, thank you. I missed you guys too. I wasn't even on social much, which is always a little hard because I feel disconnected from all of the Lawnards, but also when I am in person at events and in person things, I'm kind of locked in where I'm at. So if we are having a conversation, unless there is something urgent going on that I need to respond to, which is rare and I will normally see it through my watch, I'm locked in. I'm not checking my phone. I don't have my phone in my hand unless I was just taking pictures. I'm not on my phone. I'm in it with the conversation. And then at some point, what will invariably happen is I will go, fuck, it's 1 a.m. I have got to go to bed or I'm going to fall over. But it will go like that. Damn it. It got too late. But that's what will happen. Because when I'm in person, I'm just there doing that. And then I'll get to the end of an event and be like, I didn't take very many pictures. Shit. But I have, thanks for the memories. So. Tonk said, is there a type of law with decent work-life balance? It really, 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 it really depends on where you work, on who you work with, and what work that you do. I think contract research attorney work could be very work-life balance because you can pick what you're doing. In-house counsel tends to have a bit of work-life balance. It really, company culture matters a lot, and that's the same in law firms. Government work, I think, takes a little bit more balance, but at the end of the day, it's like, what are you going to do? Keep giving me more work? I'm going home. But the work is so heavy that you push, or at least I did. I did not do a good job of building those boundaries for myself because there was always so much to do. And I felt like I was constantly on a treadmill or a hamster wheel trying to keep up with the amount of work, thinking that at some point I would get to the end of it, but there is no end. Like, joke's on you, there's no end. The more you get done, the more you're going to get given. So I needed to build in I'm stopping, and I was not great at that. Steph said, thinking of a paralegal career. Your thoughts? Paralegals keep the legal field running and are incredibly needed. Also, if you work for people who are great, you will have a great experience. You saw in the Alessi interview how much he talked about those that he worked with and how much he respected them. If you find a good working relationship, it will be great. And you get to choose. Like, you get to choose. So that, let's see. We had some Kelly, this is a very generous super chat. Thank you. Kelly said, I'm way behind, but I wanted to say, Emily, I waited to look at this motion specifically so I could do it with you and the Nuds. Happy to see that face. Happy to see you guys too. Very much. And Orbiter Dictum said, name for a dessert cafe, Schrodinger's cake, where you can have your cake and eat it too. I love it. It needs to be like a pop-up. It just all over the country, and it just pops up without being told, and it just pops up. I think that would be really fun. So let me see. Elizabeth D said, I saw MCR in Toronto. It healed me so deeply. The saving grace for me being in Tampa is that I got very hot going up and down stairs and stuff. It was just warm. So you couldn't really tell that I was just crying the entire time. But I cried through most of Evanescence's set. And I can't, there aren't words for how much I love Amy Lee. And so I just cried. And then I just cried. It was great. It was so much fun. Scream singing with thousands of people is an incredible feeling. And it just lets you remember that there are people that you don't know in the world that love the same thing that you do, and getting to be in the same space, that energy is so good. And some people love a sound bath. I do too. It's just that I go to concerts and bring ear protection because they're very loud, but it's the same thing. Just, it zhuzhes the vibe. So if you can go to the show, go to the show. Get the cheap tickets, go to the show. Sound is sound. Go to the show. Christina S. said, my 10-year-old just signed up for band after seeing T do DCI. I love to hear it. Look, go watch the marching band. You guys, if you have kids in high school, even if not, go watch the marching band. It's so much fun. So music is good for the soul. Music is good for the soul. Whether you play it, whether you listen to it, whether you play it badly, music is good for the soul. Absolutely. Kabuki said, I can't wait to see MCR in February. I am so torn about the MCR show, about whether I wanted to know more about it before I went or I enjoyed jumping into the lore after. I have loved jumping into the lore. I knew a bit about the shows, but I have enjoyed diving into all of the lore afterwards and all the YouTube videos breaking down the entire tour and experiencing the show without looking at set lists, without knowing all of what to expect. I really enjoyed that. And getting to like jump around and scream teenagers with my teenager was amazing. Just absolutely amazing. So, Lindsay said, I miss big concerts. I refuse to Ticketmaster. Lindsay, we are going to be talking about Ticketmaster in the podcast this week, among a few other cases, because Ticketmaster's having a moment. So we're going to talk about that. Carrie asked, EDB, do you play any musical instruments? I played the drums, and then I switched to color guard, but I do not play any other instruments, and I probably don't play the drums well anymore. I have not done that. Frankie's mom, I have very complicated and deep thoughts about the Remarkable vis-a-vis the Supernote. I like the organization on the Supernote very much. I like reading PDFs on the Supernote very much. I think it's more cost effective than the Remarkable. I like it. If you already have a Remarkable, I wouldn't get rid of it. Remarkables are expensive, but I like the Supernote better. As we've gotten into it, I like the Supernote better. Also, the Supernote syncs for free with your Google Drive or whatever you choose to sync it with. So there's a free sync. I really like that. So I enjoy it. Crystal said, I'm not far from 3 years. Time flies when you're having fun. I mean, time flies when you're a law nerd. I agree. And I feel that. I absolutely feel it. So let me see. I'm going to get to 2 other comments and then I am going to run because I've got to go to football. I got to go to football. I got to go get some cheese and crackers and then go to football because we have to do it. Cassandra said, I have the Supernote and I still love it. I wouldn't trade the Supernote for the Remarkable. I did go through Remarkable nibs pretty quickly and it started getting frustrating. So that was frustrating. Let's see. A lot of you are like, I play drums too. Would love to learn to play the piano. I totally get it. I hate Live Nation. Ticketmaster, same. But I love live music, same. It is a battle. We can talk more about MCR on members only for sure. We have some other things to talk about. So it's all part of this trip. So we will talk about it. But yes, I do not have fond feelings for Ticketmaster. I just don't. And the thing is, it fucks over the artists, and it's so frustrating because it hurts the fans and it hurts the artists. Somebody has to facilitate ticket sales. But the way that the tickets resale through Ticketmaster, I covered it with the Taylor Swift lawsuit. It's just usurious, and they are making so much money off of fees on all sides. The artists don't get that money. Look, if the artist got that money, I'm fine. Support live music. But the artists aren't getting that money, which is why I will buy merch at just about any tour I go to, because it's really where the artists make the most money. So I will always buy merch because at least I know that's going to the artist. The rest of it is frustrating. Jessica, I have seen a lot of comments about this case. I have heard of it from y'all. I have no idea what it's about. So I actually know more about the David case at this point than the Kelsey Fitzsimmons case. I do not know anything about it. I have it on my docket to take a look at because I've been asked about it. I've seen it in the comments and I've seen it in my DMs too, that and the David case. So I will take a look at it before I can let you know whether I will or won't. But I will take a look and see, because we also have the Brian Walsh case going to trial next month. And I think it might be getting close to a time to jump into the Brian Walsh case as well, right? So when I will cover some of the newer things, I'm not sure, because we are mid-September. Brian Walsh is starting in just a few weeks. And then we've also got to catch up on some of the civil cases. So I have it on the list we will see. But we have some things we have to get to first because I really want to cover a couple of days of just covering the Cardi B trial with covering the highlights from that for sure. And then we have some hearings that we are behind on. So we've got to decide if we're going to cover all of the hearings from Trooper Proctor or not. I might wait till we get close to the second part of the hearings because I covered it in the podcast last week. So it's on my list. I will take a look and then I can let you know better if and when we will be covering it. A lot of you are like, yes. So I will take a look and let you know because I know truly nothing about it other than I've seen the name repeatedly of you guys asking. So your interest in a case, I need to take a look at it, but your interest in a case and then how much access we have to get the information is a huge part of covering it. A lot of you are like, Massachusetts. All right, Law Nerds, I'm going to go look at some high school football. We are going to be recording a podcast this weekend. So members, I will post in the member space. I don't know what day this weekend we will look at yet. I'm not sure. So I will let you know in the member space. We will do a members only live this month. Once I have it scheduled, that will be in the members space because Dr. B and I haven't even had a chance to look at calendars because I've just been on a plane for the last 2 weeks. It is good to see you. I'm sorry the voice is a little janky today. I have talked much and the air travel, truly, that much air travel is just, eventually it gets you. So Law Nerds, take care of yourselves. It's good to see you. We have much to talk about. I will see you on Tuesday. Members, I will see you to record the podcast. I'll let you know. With that, take care of yourselves. Take care of each other. Stay hydrated. Law Nerds, we've got this. We got it. Just pick a hobby to engage in this weekend. Get offline. That's what I'm going to do. This weekend, I'm going to set up new phone and play with focus modes and camera. I'm going to take pictures of my yard and my kiddos. I'm going to read. I've got a book that I haven't read that has been on the docket. And those are the things other than recording the podcast that I'm going to be running away and engaging in this weekend. And I think I need to go look at the Mr. and Mrs. Murder because all of you pointed out that that's that case. And we're going to have to look at that too on our side track. So we're going to have to side quest. Hopefully you have a good weekend and comments when you've gotten here. Let us know what you're up to this weekend. So you're getting out and doing things because we all need it. All right. Law Nerds, you're the best. I will talk to you soon. Have a good weekend. Take care of yourselves. Take care of each other. And a huge thank you to today's sponsor, Incogni. Get your info off the internet too. You can get that set up this weekend. It's a good plan. All right. I'll see you guys soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.